Friday for admission. Ma'am.
Admission. What is the matter about?
And one is a contractual payment and other is relating to settlement of the ferry services.
Meet with the Lordship. My Lord, I beg to mention for posting of an urgent matter. If convenient for my lords, can it be taken up today, my lord?
Motion matter.
Motion matter.
What is the urgency?
My lord, this is relating to the tender process in which my lord, pardon me, couple of days back, they have introduced a similar clause wherein they have debarred us from participating. Earlier, that particular clause was not there in the tender. Like my lord, annual average turnover, which was challenged in my lord, in few.
This is a tender regarding what?
My lord, a supply of my lord, Napier slips. Napier is of order grass, my lord. So it is by the same agriculture department. And the last date is 20.
Have it tomorrow?
Yes, madam.
Tomorrow. Today is a Tuesday. Tomorrow. Have you filed it or not?
Yes, madam. We have filed it, madam. I'll oblige, madam.
Lordship, item number 19, I'd like to seek a short adjournment. Senior counsel is busy.
19.
Difficulty, yeah. Item number 19.
My lord, in this case, item, my lord, I am appearing for reference 4, my lord.
For?
In item number 19, my lord, I am appearing for a reference number 4, my lord.
Yes.
Let me be hard on Friday, my lord.
Friday? Monday? Okay. A prayer for adjournment has been made on behalf of the petitioner. On the other hand, on the other hand, urgency has been expressed on behalf of the respondent number 4. Para. Accordingly, list on. First is a holiday. We'll have it on Tuesday next, 2nd. 2/5. Third, 3/5. IA is for, what is the IA for? Modification. Okay. Yes. When? Tomorrow? Today? When? Have it tomorrow? Withdraw list, whenever you want. What is the stage? Motion. Friday, no problem. Have you filed it or not? It will not be listed otherwise. Why? No. Why, if you have filed it today, why will it not be listed on Friday? Oh, that's a different matter. You can file it tomorrow, day after. Okay, have it Friday.
Highly obliged.
Today's daily list admission item number 22. 6.
Yes. Have you filed or not? What is the matter about? You have a building which construction is going on? Where? Purupothar. Okay, I'll have it tomorrow. When do you want? What is the matter about? Trade union. Okay, Friday.
Item 1 and 2.
But we had fixed it today because he is expressed urgency. Not Friday, then we'll have it day after tomorrow, Thursday. And we're going to dispose of this matter. Don't take further adjournments.
No.
A prayer for adjournment has been made on behalf of the Forest Department on the ground that instructions have been received very recently, full stop, para. On the other hand, comma, urgency has been expressed on behalf of the petitioner, full stop. Para, considering the same, that the matter be listed again on day after tomorrow, date for admission, for motion.
Always, madam.
May I please your lordship?
Yes.
The matter pertains to
Yes.
compensation claim. My lord, yesterday a hearing was taken by the competent authority regarding the matter of compensation, and the competent authority has issued a direction to the ADC to properly demarcate the land using a team of lakh mondos, my lord. And the decision will be taken by the competent authority after 2 weeks, my lord. The date was not given because the detailed order.
We'll have it after 2 weeks then.
My lord, this case is regarding competent authority. This court has nothing to do, my lord. If you're not satisfied,
Understood. He has got the avenue to go to the
yes,
appropriate court.
so let the matter be unnecessary dragging out. Let the matter be disposed of,
My
my
lord,
lord.
in this matter, lordship may.
But this court has nothing to do, my lord.
And in one, from one side, Mr. Mitra is right. Your grievance has got nothing to do with this writ petition. If you think that there is the development, positive development towards making a towards making an assessment. If you are aggrieved, you have the remedy somewhere else.
My
Do
lord,
you think the writ petition will be helping or coming to your benefit in any way? I don't think so. We withdraw this, we'll give you liberty.
my lord.
Okay. Heard Sri S. Vikas Learned Counsel for the petitioner. Also heard Sri S. Mitra, Learned Standing Counsel, Gail, whereas the state is represented by MSS Sharma, the Learned Government Council, full stop. Para. The issue was with regard to, the issue is with regard to the assessment of compensation for damages claimed to have sustained by the petitioner by the while in the construction, not while, in the construction of the right of way,
Yes, my lord.
right of way of the Gale, full stop. Though this matter was taken up on a couple of occasions earlier, because the Learned Counsel for the petitioner has submitted that yesterday, that is yesterday,
My lord.
for instance, there has been some positive development wherein the concerned officials have been directed to make a fresh assessment of the loss claimed to have been suffered by the petitioner. Full stop. This court has also been apprised that there is a scheme for filing an appropriate application in case an aggrieved party is not satisfied with the adequacy / sufficiency of the compensation. So, Sarah, in that view of the matter, because the Learned Counsel for the petitioner craves leave of this court to withdraw this writ petition, however, with a liberty to approach the same if the need arises. Full stop, para.
No, one para maybe, my lord. They are coming with this type of petitions, so one cost may be imposed, my lord. That we noted, if a lordship given or not, that because I'm also pressurized by this type of this thing is coming out every time.
Writ petition accordingly stands dismissed on withdrawal with liberty as prayed for. In an appropriate case, yes, not this case.
Tell your place.
Next. Can we have it day after tomorrow or Friday? We'll have the affidavit. You have filed it today, I think. You have been served copies, okay. Sri S.K. Goswami, Learned Counsel for the petitioner submits that in terms of the order dated 30/3/2023, an additional affidavit has been filed by the petitioner today, which however is not tagged with the records. Full stop. Para also heard Sri D. Gogo, learned standing counsel forest, as well as Sri D.J. Das for learned, you are standing counsel. CCC, learned CCC, appearing for the railways. Para, in the interest of justice, place this matter on Friday. On
Next week.
next week. Next on 3rd.
I'm really apologize.
On 8th May 2023. Full stop. Registry to tag the affidavit said to have been filed today. Additional affidavit said to have been filed today by the petitioner. Para, interim order passed earlier to continue till the next date of listening.
Much.
May it please your lordship.
Yes.
My lord, on the last occasion, we moved this writ petition, my lord. This writ petition relates to operating 130 mobile medical unit ambulance in the different districts of Assam. I am the existing player. My contract was till 2022. It was extended till 2025. It's taken by the government of Assam. But now what they had done initially, they have given me extension till January 23rd by Korean or whatever agreement it is there. Now my next extension will expire on 30th of June 2023. In the meantime, my lord, what has happened in the last
You said that you have been extended to 2025.
2025, it's the original, it's the total extension.
Okay.
But what they are giving is that they're extending it in phase wise. So in the meantime, what has happened? They had issued a tender notice in October 2022. I also participated in the tender process. That when the technical bid was open, my lord, it was
This
open.
is for the same job.
Same job.
But you said that you have been, you are already allotted till
Yes,
25.
but my lord, we are a businessman, my lord. We initially did not thought of going into loggerheads with the government because we know that we are the persons only who can have this manpower as well as the vehicles. Since we are operating in Assam, we know that even if we compete in the competitive tender process, then we'll be successful. So we decided to participate in the tender process. When the technical bid was open, my lord, the technical bid was opened, I think, on 8th of January, and on 10th, my lord, the price bid was open. When the price bid was open, we find, my lord, that our bid and their bid value of the private respondent number here is that there is a difference of 265 rupees only. We have doubt that our rate have been given to them. Others, this margin with their infrastructure and all, it is not possible either than an existing player.
How much was your bid?
My lord, I'll come to that, my lord.
No, how much is
Yes,
not exactly, just magnitude.
Your lordship will see page 133.
We don't need the exact
Yes,
figures.
yes,
Just tell us the
yes. My lord,
approximately.
yes, my lord, just a moment.
Crores or lakhs or what?
It's a difference of only 200 rupees.
No. 200 is
Yes.
not the, how much was the bid?
My lord, it is given as, my lord, 1348500 is there, and ours is, my lord, 13750.
1 crore.
But it will be during the entire period, my lord, the contract value goes up to 6.5 crores and more.
Oh, in 6.5 crores, the difference is only 200.
Yes. That's why we have doubt, but presumption and all will not be due unless we have some concrete evidence to show that they have leaked it. But we have doubt because an existing player who has 131 MMU and they have only, my lord, your lordship will say.
What is the challenge?
Now, when the technical bid was open, my lord, your lordship will find, your lordship will first look that what are the three criteria that has to be looked into the technical bid to allow anyone to have mobile medical unit. Because normal ambulance is 108. And MMUs are those which have the life-saving equipments there and all. It's a highly expensive. You have to have a doctor and all those parameters are given in the tender document. Your lordship will kindly see first what are the three conditions that are required to be have in the when the evaluation of the technical bid is done, that your lordship will find at page 77.
No, we'll go into those.
Yes.
You are already protected by an interim order. Have they
Interim
filed any returns?
order is only to the extent is to the the council has given an undertaking that nothing will be done since the matter will be sub judice, and that is as good as an interim order
But
because
no selection of tenderers. You have not selected.
Already LOA has been issued prior to that order, my lord. Now I have it in the record, my lord. Lordship let him complete, my lord, I will place, my lord.
Yes.
I've got otherwise I've got the records also.
so your lordship will look into the record. It can be I'll just point out the minimum requirement that is required to show that the balance of convenience is in our favor and no irreparable loss.
When was the LOA issued?
My lord, the LOA was issued on 29th of March.
That we are aware, my lord, we have made a mention that copy was not given.
29th of March 2023.
And then, my lord, comes the performance security. Then the agreement. Well, I don't know whether the agreement has been executed or not.
Agreement already, my lord, signed and submitted by the LOA, L1 bidder.
On which day?
It was submitted on 12th of April.
My lord,
And that performance guarantee was submitted 10th of April 2023.
then, and this
10th.
agreement was submitted after the filing of this writ petition.
No, even then, we were not on record, my lord, not even the petition.
My lord, because there was an undertaking that they will not sign the agreement, because this order, this is a file on 10/4/2023.
What is the observation? What Mr. B. Gogoi submits that he will inform the respondents that as the matter is sub judice, no selection of the successful tenderer in pursuant to the NIT should be made till the next date.
Well, leaving aside that observation, I will show, my lord, prima facie, because the record is there. Your lordship has to see only one, your lordship will not take much. I'll prima facie satisfy your lordship that this is a case where an interim order can be passed as per the facts of the case. But I will just, your lordship will give me that indulgence.
No, these are matters of essential service.
Yes, my lord.
Instead of going for an interim hearing, we'll have it day after tomorrow, final hearing. Are you ready?
Yes, my lord.
We'll see the records.
Yes.
If we
In fact,
find,
my lord, the extension has been given to the present petitioner till June of this year,
Okay. My lord, may
30th of June.
I also
And
comment?
lordship, so far as the, my lord, earlier contract is
No,
concerned.
Mr. Gogoi, you may be correct in that respect.
Yes.
As an existing tenderer, will not
Yes.
will not consider his case, but he has made an independent challenge with regard to the criteria.
That I will satisfy.
You can address only on
Then
that.
day after
My
tomorrow.
lord, with your day after tomorrow,
after
my lord, with your lordship permission, may I also look into the record once, my lord?
My
Just
lord,
a minute.
first-
Whatever is there is
first
the, my
let us-
lord, technical bit minutes and financial
First
bit
let
which is
us have
already
a look.
uploaded.
First, let us have a look.
Fine.
If we think that there is something which you
Yes.
are required to be made privy to,
Yes, yes.
we'll
Yes.
allow you to
Yes,
inspect.
ma'am. But it's no use keeping it pending because it's an essential service. It has to
See,
be taken to its
we
litigation.
are not inclined to pass interim orders and have this matter hanging.
Uh-huh.
Either you have it or they have it.
Yeah.
But, uh,
Lordship.
Yes, ma'am.
Lordship, I appear for the private respondent. We filed a wakalat.
You'll be filing affidavit.
Not,
Everything is in the record. but-
Will participate in the hearing after the mail.
No, that you have all the liberty. When did you file the writ petition?
Well, on 10th.
And Arts Tribidi Learned Senior Counsel for the petitioner who is aggrieved. Petitioner is a trust which is aggrieved by the outcome of a notice inviting tender dated 1/10/2022 for selection of participants to operate mobile medical units within bracket MMU 4S to provide primary and secondary health care services in the state. Full stop. this court by order dated 11/4/2023 had granted a liberty to Sri B. Gogoi, Learned Standing Council, Health and Family Welfare Department to produce the records, and had also made an observation that the interim order would be considered on the next date. Full stop. The undertaking of the Learned Council for the department with regard to the fact that he would inform the respondents that since the matter is sub judice, no selection of the successful tenderer in pursuant to the NIT should be made till the next date. Full stop. Sri Gogoi, the Learned Council for the department, has however submitted that even before, that long before the third order was passed and the undertaking given, the LOA was issued in favor of the private respondent. And also he further submits that the petitioner was also aware of it. And in fact, the incumbent was already made a party respondents in these proceedings, which is represented by MS A. Verma, Learned Council. Full stop. It is also submitted that in the meantime, the agreement has been signed.
Well, signed by the petitioner, not by us. Well, he has submitted.
The signed agreement.
Sorry, by the
The
respondent.
signed agreement by the respondent
Has
number,
been submitted to us.
by the respondent number
Respondent of 4.
4
Yes.
has been presented to
Yes.
the department for consideration, along with submission of performance guarantee. Full stop. Para.
And because of this, my lord, assurance given, we have not, my lord, till date signed the agreement from our side.
He, however, fairly submits that that in view of the undertaking granted, the work in question
Yes,
has not been handed over
lordship.
to the private respondent. Full stop. Para.
No.
Not para. Sri Gogoi is also equipped with the records of the case. Full stop. Para. Sri Kuan, the Learned Senior Counsel, fairly submits that under such circumstances, instead of hearing the parties on the interim consideration, full stop, the entire writ petition can be heard, as the services in question is of essential nature, and any order of suspension may not be in the interest of public. Full stop. Para. Not para. At the same time, the senior counsel submits that urgency is there. Full stop. Para. In view of the aforesaid submissions, and also taking into consideration that the records of the case have been obtained, list this case for motion hearing on day after tomorrow, 27, on which date an endeavor will be made to dispose of the entire writ petition.
We are obliged, madam. And Mr. Gogoi has been kind enough to say that he will give me the LOI.
Yes, copy of the LOA I will furnish.
Diplomacy.
Mr. Kaur, you can just make a gist of your
Yes.
argument, the
Yes.
points, only one page.
Yes.
And in the records, kindly make the Mr. Gogoi
Index record.
flag marks the flag
Yes,
mark
yes, I will give a list, my lord, including the.
and flag marks.
Okay.
Yes, madam.
Okay, pass about the matter for the time being. My senior legs in court number 7. Lordship, this matter, I'm still awaiting my instructions, Your Lordship. Matter was last listed on 12th. Just before the BU holidays. Because of the holidays, Your Lordship.
Okay, you have the instructions, we'll have it next week. 1 week is enough for you, or 2 weeks?
Yes.
Lordship,
only thing-
PWD was also included in this matter. Lordship, the instruction from the PW department is also
Who is for
required.
public works?
Madam, our names are not reflected, probably we missed.
You have the instructions delivered after 2 weeks.
Lord.
Madam? No, Madam Sharma.
My lord,
Yes.
yes. Well, the only thing, if I may most humbly draw your lordship's attention to one aspect of the matter.
Hmm.
That everywhere the petitioner claims that it is the land of her mother-in-law. He produces a next of kin certificate saying that her husband, she claims that that man in whose name the next of kin is issued is her husband, but there is no document evidencing her marital relationship with this man, Nurul Islam, at page 15, my lord. Of your lordship's opinion. Nowhere, my lord. All her representations, she claims she is the daughter-in-law. There is no document on record, my lord.
What is the issue involved?
She says that this 4 bighas land, there's a notification. They want to build a bridge over a 4-lane highway. And there's a notification where this 4 bigha land belonging to her, standing in the name of her, in her late mother-in-law's name. There's going to be a bridge on it, and that will affect the pond from which she earns her livelihood. Pond lying nearby. Fishing pond, my lord, nearby. The bridge that is proposed to be constructed.
This lady doesn't have any other legal heirs.
That is, my lord, that is not known, my lord. It's only, there is a piece of paper.
Madam, what is your name? Madam, what is your name?
Laura
Laura.
Ahmed. She is the wife of the legal heir of the deceased. Actually the acquisition was made in the name of her mother-in-law, who has expired, your lordship, in the meanwhile. So I have annexed the next of the kin certificate that your lordship.
Next of the kin has Nurul Islam.
Nurul Islam's wife is there.
Why Nurul Islam is not there? He's passed away. Or?
No, he's there. But all the communications are done by this lady, and she has also approached the authorities concerned. And the authorities concerned have also taken into consideration her applications, and even she was called for your lordship, I think there was a hearing also, and in the hearing she was called. And thereafter, your lordship.
Factually will not go, will go by law. If Nurul Islam is there,
Nurul Islam is,
Why
as
Nurul
per
Islam
my
is not-
instructions,
why is
He
not
is
before
there.
the court?
because
If
she
he
has,
has passed away, then the matter would have been different.
but as per my instructions, he is there.
What is his difficulty, or what is his legal bar, or some information that he cannot come to the court?
That part, your lordship, I am not sure, but
I think you have to approach through Mr. Nurul Islam.
and in fact, the authorities have taken this, all the explanations and all the replies, and even called her. That is why I think she was made, she has come before your lordship. And Nurul Islam has not even issued any letter. As per your lordship will see. all the
Here, what
base-
Madam, the learned government advocate, Madam Sharma was pointing out,
Yes,
in the communications, after your name, you have never described yourself to be the wife of Nurul Islam.
At page 30, she
All the
says,
pages we have seen,
at page 24, she
page
says,
30, 31,
only at
Dilwara
page 30
Begum,
there
mobile number so and so. No, even assuming that you are the daughter-in-law, there's
Yes.
no doubt.
yes.
But
I think
when the son is there,
one is there, but I don't know why. Because not, he has not come. But in fact, in the course title,
you,
his name is given as
I
wife of.
think you have to take instructions. We'll give you time to have the file your, they're taking some time.
Yes, but in fact.
I think you should also have the instructions.
I also take why.
You can
why-
add your husband's name here.
You can put both the names. I can, in fact, your lordship, if permitted, he may be made a petitioner because his
Not
wife of.
petition
so-and-so has
will be
been given.
difficult. You can transpose yourself, make an intervener.
My lord.
Yes,
Anyway.
Hartsby, Y.S. Manna, learned counsel for the petition of MS S. Sharma, the State Council, however, submits that the deceased, that the next of kin certificate of the deceased indicates that Nurul Islam is the kin who is the son. And on the other hand, comma, this writ petition has been instituted by one Dilawara Ahmed, claiming herself to be the wife of Nurul Islam. Full stop. The questions that when the named next of kin is existing, comma, there is no reason as to why some other person can approach this court and the petition be entertained. Full stop. He further points out that there is no document annexed to the writ petition to show the relationship between the petitioner either with Nurul Islam or with the deceased, except for an averment that she is the daughter-in-law. Full stop. The London State Council, according to praise for, and is granted 2 weeks' time to obtain instructions, oblique file affidavit in opposition. Full stop. In the meantime, comma, MS and Bodloy and Sri B. Gogoi, Learned Standing Council of the Revenue and Public Works Department, respectively, may also obtain the instructions that file affidavit in opposition.
No, another thing, a small thing, if I may draw a lot.
Yes.
Pages 14,
1-4.
page 14 of your lordship's brief.
Yes.
Name of the deceased is Nuran Nessa Begum. Page 19, the last line, Patta number 141, Dag number 113, Nur Nessa Begum and 3 others. They own 4 beggars. Name is Nuran here, and the person is Nur, my lords. Nur Nessa and Nuran Nessa could be 2 different persons also, my lord.
That at best, my learned friend has been saying that. Let her verify, then why these, they are going into all these issues upon my applications and conducting hearing on me and others. And now they're pointing it that Nurun Nessa or Nur Nessa. I don't know, but at least they should have verified that.
Well, the petitioner has come to this honorable court.
Yes.
He must stand on firm ground, my lords.
There are 3 others also. I don't know who are these.
Yes, my lord. The petition claims that the 4 bighas belongs to her.
Yes. The other 3 names should have been also been incorporated anyway. Come further, your lordship, affidavit in that regard, if required, I'll file.
See, in page 24, you have not even mentioned your mother-in-law, Jane. Your first application. Let us come to the vernacular spirit at page 24.
Yes.
23, there may be some mistake in the page 24.
No, in
Nibedan is a Sri
Mur Hahur Namot.
Mur Hahumar Namot 4 বিঘা নিজৰ দখলৰ ম্যাদী পট্টা জমি আছে।
There is no name.
name is not given, but.
No, in
mother-in-law-
your description, even you have not stated your wife of Nurul.
No, in the cause title I have.
Not in the cost title. The cost title you have dropped it. Here in the application.
Application, it has not been.
When you have signed,
Yes.
Dilavara, you have just given the mobile number.
Yes. Mobile number, address. His name has not been given.
Similar,
Let me also verify.
yes, yes.
If he's alive or not, I don't know. Let me verify that. And if required, then I file an additional affidavit. also.
Similarly, at page 27.
Yes, I have seen that. In all these are, it's only the address and the name. Even if
No,
required.
show us one document where you have mentioned the name of your mother-in-law.
Hmm?
30, page 30 also. You have said
Yes,
for mother-in-law.
but name has not been.
Name has not been, at least while writing your name, you should have written wife of Nurul, then also some connection. You
In
take
fact,
instructions.
I'll take those
Yes,
instructions. On that day, I'll take the instructions.
An association of registered pharmacists is before your lordship. My lord, the basic grievance is with regard to conduct of an election, which, my lord, on 2 points, primarily for the, my lord, motion stage. There are other points, my lord, we'll go later, my lord. For the motion stage, my lord, 2 points. One, there were around 3,000 fake, my lord, registered pharmacists under the Assam Pharmacy Council. Now, the government from 2017 is, my lord, behind the council that this should be, my lord, delisted or deregistered. There is a provision. What they have done, my lord, they have in the meantime, my lord, cancelled 1,190 out of those 3,000. But the balance 1,810.
3,000 fake.
3,000 fake, my lord, admitted.
Fake entities.
Huh?
They are fake, 3,000 fake entities.
Fake, my lord, registered because they don't have the qualification. They were registered pharmacists, my lord. Fake registered pharmacists.
In your union?
Not in my union, in the Assam Pharmacy Council.
Okay.
And my lord, because there are persons beyond our union also, my lord. Then, my lord, out of that, around 1,190 were cancelled.
How many cancelled?
1,190.
On your insistence?
On my assistance and the government's direction.
That is
Government's direction.
you have taken initiative.
And, my lord, 1,810 still pending.
Okay.
Lordship. Now, my lord, what happened is they notified for elections. Then, my lord, there was a hue and cry in the media also, my lord, that was highlighted in the Facebook also. The petition number 2 made some posts. Now, he was given a legal notice. My lord comes to that legal notice at page 48.
Who was given?
The petition number 2, my lord, by the APS, by the Assam Pharmacy Council.
Pharmacy council gives you a notice?
Yes, your lordship.
Why?
Saying that, why have you made all these allegations? We are taking steps that this, my lord, may come to page 48. This is the legal notice sent by the Assam Pharmacy Council. Relevant, my lord, would be
Page 48.
48, my lord. 13/2/23. Elections were declared on 10/2/23, my lord. And my lord will have page 50, my lord. I'm sorry, my lord, the number will be just reversed, my lord. It will be 1190 pending and 1810 cancelled. Sorry. Fifty, my lord, page 50.
What is 50?
My lord, it's part of that legal notice. Just a fact has been stated. I'll just place that before your lordship. A bare perusal of the above, it is clear that the registration numbers of total numbers 1810 pharmacists have been cancelled permanently and their names have been removed by my client only after decisions of so-and-so, thereby writ petition, writ appeal, revision were filed. As such,
Process is on.
lordship.
Process is on to cancel the other.
1190. Now, this is one aspect, Lord. The second aspect, my lord, would find, if my lord comes to the letter by which the notification by which the elections were declared, which my lord would
Now,
find.
what is your grievance?
My grievance is, my lord, the voters list is not correct.
When is
Because,
the election?
the elections are on 27, 28 and 29
Of this month?
of this month. My lord, page 44, my lord, would come to.
Elections for what?
For, my lord, 6 members from registered pharmacists.
Elections as regards what?
The forming of the council, my lord, Assam Pharmacy Council, 6 members. will be from the page 44, my lord.
54.
44.
44.
my lord would find it is for the general information under so and so governing Assam permit, calling upon pharmacists registered in the State Pharmacy Council under section 32(2) of the to elect 6 members of the State Council under clause so and thereby fixing a program time below for forthcoming election held on 27, 28 and 29 of so and so from 7 a.m. to 5 p.m. which will, my lord, will note this, my lord.
Who are the voters? The
Registered pharmacists, my lord, including my members, my lord. My lord will see, which will be conducted
and
usually.
this still includes 1190 allegations.
My lord, it's identified. They have not cancelled, my lord. Because in
Who
2012,
has identified?
the government by through away of an inquiry, because the government says, my lord, 3,000. I'll
Oh,
place it.
there is no anomaly, there is no dispute with
No, my
regard to
lord. My lord will come to page 39, the direction of the government.
Yes, yes.
My lord, regarding this illegal or fake pharmacies, my lord, several litigations were held, my lord. Thereafter, my lord, in a series of cases, a direction was given to us that, my lord, will give them an opportunity to submit their, my lord, documents. Thereafter, my lord, if we found them to be
Right.
final so cause will be given and thereafter they will be terminated.
Right.
That process has been completed. And my lord, to my knowledge, this 1810 has been already terminated.
Right.
So rest part, my lord, 1190, my lord, I can have the instruction, my lord. Let it be tomorrow, my lord.
Tomorrow, but 27 when today
And there is another factor, my lord.
today is
Today is 25, my lord. Well, there is another factor, my lord. If lordship comes back to page 44, it has
this
been
is my secret ballot.
No, well, that's the problem, my lord. Here, my lord will come to page 44. They say this time the election will be by online mode, digital mode. Digital mode. They will, my lord, give through links to all the pharmacists, and then they held a mock one. Mock exercise was held. In the mock exercise, only 2% to 5% people got those links, madam. Now, there is a set of rules. It's, my lord will come to
Let
page.
him have the instructions. Tomorrow we'll have.
Tomorrow, my lord.
Tomorrow.
Lordship.
If they come up with the instructions that pending, in the meantime, this 1190 shall not be allowed to vote, then matter ends there.
That part,
But my lord, they'll have to, my lord, there is a statutory violation also, because this election is being held in online mode. Whereas, my lord, the rules, there is a specific rules for this organization. My lord will come to page 23, my lord.
And that is a different.
Notification is of February 2020.
No, because
all
my
the
lord,
delegations there.
Mr. Nair, that is the different component of your challenge.
Lordship.
We'll examine that.
Lordship. My lord will have it tomorrow, no problem.
But immediate concern is whether 1190 whom you say that they are not eligible, whether they'll be given a chance to vote. If they're out, then yeah, substantially you get the relief. And the mode of election we can decide.
The mode of election, the rule says that you will have to send ballot papers by registered post. Now they are saying online without even amending that, my lord. That is not, that also instruction let my friend take.
Yes, both are going.
No, you are correct that rules have to be followed, but what is the prejudice you are going to suffer?
Because, my lord, this
You're
links.
the council.
No, this links, my lord. This link, sanctity of the election, this links that were sent in the mock exercise reached only 2% of the people, my lord. Others did not even get it, my lord. This is all being done so that a body comes which will, my lord, favorite somebody to be the president. That's my allegation, my lord.
But how can the council make such a grievance? As an individual, somebody can come and say, but
No, we are the registered.
whether
No, no, no.
favorite persons make the
We
council.
are the Assam Registered Pharmacists Union. We are the
So you are the union.
I'm not the council, man. I'm the union.
Okay. Yeah.
Because it's our constituency, man,
Okay.
6 seats.
Heard you can hire counsel for the petitioners who are aggrieved by the inaction on the part of the respondent authorities in rectifying the apparent anomalies in the voters list pertaining to the elections of the Assam Pharmacy Council.
Assam Pharmacy Council.
Full stop. It is the case of the petitioners that a large number of fake registration was there, which was pointed out, in which the union played a major role. And in the meantime, 1810 number of such fake registration have already been cancelled. And action is yet to be taken for the remaining 1190 such registration in spite of those being determined to be fake, full stop. On the other hand, the senior counsel submits that if these 1190 fake registration, fake 1190 incumbents with fake registrations are allowed to participate in the election, the entire election would be made nugatory and immense prejudice would be caused. Full stop. The petitioners have also raised an issue with regard to non-adherence to the established manner and mode of holding the election. Full stop. Para. 3. B. Gogoi, the Learned Standing Council, Health and Family Welfare Department, however, submits that action for cancellation of 1810 has already been taken and the process is on to cancel the remaining 1190. And this fact was already made known to the petitioner in the legal notice served upon the petition number 2. Full stop. He prays for some time to obtain the instructions. Full stop. Para. Considering that the first date of the election has been notified to be 27 April 2023, let this case be listed for motion again tomorrow. That is so. By which time we go, the understanding council would have the instructions.
Much obliged.
Here, Your Worship, I have filed my objection today, Your Worship. And the RERA has also filed an affidavit in opposition today also. Matter may be taken up on 2nd of May, Your Worship.
You have filed the IA for vacating.
Against that, I am they have filed a
Now, what was the case?
Like, is that my lord,
My case,
You had a repetition.
now my case is that, Your Worship, an order has been passed, Your Worship, without hearing me. That's precisely the case, Your Worship.
Order for demolition.
Yes, Lordship. That has been passed by on the direction of RERA, Your Lordship. This order has been passed. That is our allegation, Your Lordship. And they have, there is a stay order passed by the Honorable Court, Your Lordship.
And you are appealing for whom?
I'm appealing for RERA.
They have also filed an affidavit.
RERA is just number
3. It will not take much time, Your Lordship. May fix it on 2nd.
on 2nd. Okay. We Portakur, as Portakur, and conflict for the writ petitioner, for the opposite party writ petitioner has submitted that the objection affidavit has been filed today by serving copies upon the applicant, respond number
Is
I'm the applicant here. That's why
number 4.
4 and 5. Stop. Mr. Goswami, for R3.
Yes, ma'am.
You have filed affidavit where? In the main case?
Yes, in the main case.
Oh. Respond number 3 has also filed the affidavit in the writ petition, which however is not with the records, full stop. let these cases. Let this case along with the I be listed on 2nd of May, along with the objection and affidavit filed by the parties in the meantime.
Interim order shall continue till
Para.
then.
Interim order passed earlier to continue till the next date of listing. In the meantime, parties said to have been filed. Okay, next.
In this matter, my lord, affidavit has been prepared and sent for vetting. I need 2 weeks time to file, my lord.
Anything? MS M. Bourbon, Learned State Council. Pays for and is granted further 2 weeks time
My lord.
to file the affidavit in opposition. Yes.
Well, date may be fixed.
List on
Well, the 8th.
on 8th of May.
My lord.
Well,
Yes, what is this?
may it please your lordship. We have come against the order passed by the Board of Revenue, my lord. You are agreed by Board of Revenue, but before going to the judgment, my lord, I'll just place it. What are the facts? And there are 3 points which I have to argue in this case. But before that, my lord, I'll just place it. What was the case about in a very short? My lord, kindly see 40P, my lord.
You are arguing for disposal or what?
I am arguing for the petition.
No, for disposal.
Whatever is.
No, if you are asking, are you ready for the disposal? And who's for the government? Records are there. If you're both the parties are ready, we can take it.
Records are said.
Records are here. Records are here.
Yes.
Yes, what is it?
Yes.
Who are you?
My lord, the petitioner before your lordship is the owner of a plot of land whereby right of inheritance I inherited this property of my father.
How many petitioners are there?
There are, my lord. My lord, there are about 5 petitioners in this case.
5.
5. Granddaughter.
You're all
Grandson. Yes, legal heirs.
legal heirs of Kanak Bura.
Correct, my lord. Kanak and Jagada. And at page 44, that's what the order passed by way of inheritance circle office at page 44. At 43, Jagada at 43, at 1 is Simudi Jagada Gohai, father of so and so. Petitioner number 1 is Sarveswar Borgohai.
Deveswar.
Son, yes, son, Sarveswar and Deveswar. And that was substituted by his legal heirs, all the legal heirs. At page 44, go, as per order of, at next page. As per the order of the sub-deputy collector dated so and so, 81. The name of this so and so is mutated in place of Timothy Jagada Gohai in Doug number so and so.
Okay, this government is corrected.
Yes, inheritance. And in the year 1981.
Corrected. Your names came in.
Yes.
1981.
Yes.
Names of petitioners recorded.
Yes, correct.
Then what happened?
Now, my lord, at page 50,
Yes.
at page 49, Kanak Chandra Borgohai at 49. 49. Kanak Chandra Borgohai at page 49. Kanak Chandra Borgohai, next page, page 50.
Yes.
As per the order of circle officer, the name of 2 and 3 number so and so part is mutated in place of number 1 as inheritance. So this is 1 and 2.
With regard to Jagada and 50 with regard to Kanak Chandra.
Kanak.
Okay, what is the
Right,
problem?
Mala? Then after, we are paying the revenue receipt from 53 onwards. Revenue receipt has been paid. Now the problem started from page 73,
7-3,
73.
yes.
Now the problem started with 73. My learned friend's client, Nityananda Gogoi and Debeshwar Gogoi, they alleged to be a Khatian holders.
Okay,
They alleged to be a Khatian holders. They filed this application, kindly see, after 30 years. That means they filed on 28/10/2010.
where do you get the date?
That kindly see the SMEs
Page,
74. My kindly see on the left hand side,
hmm,
on top,
Hmm.
28/10/2010.
28,
10/2010. So
application by respondent numbers,
respondent number
4 and 5.
4 and 5.
this is under the 71 Act or what?
This is yes, Assam Temporary Settled Areas Tenancy Act 1971. So they filed this application. Your lordship will kindly note down, this application has been filed after 30 years. Or on the date of the original, my lord, the owner, Konok and Jogoda. Now, interesting, this application has been filed on the name of a dead person. Your lordship will find their application is for cancellation, the name of Pattadan, issue Patta in the name of Rayati. So see at page 74.
Where? Maybe cancelled, okay.
Yes,
74, yes?
yes, 74 kindly see. Dorkhastakari, Nityananda Gogoi, Debeshwar, Ubhayar Pita, Mito Puto Gogoi, Nibaki so and so.
Hmm.
Pattada name you'll find in paragraph 1.
Yes,
Lordship got it?
yes, yes.
Yes. Now, this application was filed. Certain documents were annexed at page 80 when notice was issued, my lord. At page 84, notice was issued in the name of a dead
Oh, just a
person.
minute,
84.
just a minute.
Yes.
For cancellation. And name. Petitioner. To. uh, 80.
At
Oh.
84, when this application was filed,
Hmm.
someone was issued by the court. By the,
DC.
yes,
Uh,
additional deputy commissioner. Someone was issued notice.
Yes.
So kindly see, it was served to Konok Chandra Gogoi, who died in Gohai, Konok Chandra Gohai, who died in the year 1978.
Where do you get?
81, 84, my lord. Page 84. Page 84 on the
Yes,
2 columns, you'll like it, name of the applicant, name of the landlord
Landlord.
and his address.
right.
Now page 86. 86. Late Konok Chandra Gohai. This is a report of the process server at page 86.
Will come?
Yes, yes.
Received and signed.
Yes. Against the date. Page 86. Now,
Oh,
At-
what is this implication? Page 86 top?
I'm sorry.
What is the implication? Page 86 top.
Yes,
First.
yes. 86. No, 86, what we are saying, when the application was filed, application was filed by the respondent. Now, the notice has to be, notice has to go.
No, no, that we have understood.
Yeah.
No, what is the implication? What somebody has late Konak Chandra Guhan.
Yes,
Obviously, this for somebody who has, and for what, what is the next line for?
Purnachandra Borgohain. I don't know, my lord. But whatever may be the reason, my lord, whatever the reason, notice was served to the particular, the father and
Now, what
mother
is the endorsement?
endorsement.
10-1-2011 তারিখে what is this?
উল্লেখ্য জাননী তারিখে সহি করি দিয়ে দিছে পূরণচন্দ্র বরগোহাইয়ের সাইন।
তারিখে জাননী উল্লেখ না জাননীর উল্লেখ
জাননী
no, no.
সহি করি দিয়ে My lord, this is what, my lord, it was served, notice was served. We have taken that point at the time of objection at page 90. Kindly see, my lord. Page 90.
90.
90.
90.
Objection was filed by us. That is the main ground we have taken. Kindly see, my lord. That after the death of parents long back in the instant objective, obtained mutation became recorded partner landowners and partner land revenue regularly since after mutation possession of land under PP number so and so. A mutant the records of they became the landowners. There remain no tenant of there in this land on which land revenue also is paid till now. Number two, that there was and is no claim by anyone till now as tenant after the death of the earlier landowners and now remain tenant in the said portion of land till now, and no rental is paid by anyone as riot. That the instant landowners of the afford land has any tenant of their complying any terms and condition, tenancy now in payment of any rental as such. That the notices of the above case was served on dead person will be claiming also on account of dead person, not against the existing landowners, partner and holders. Under the certain no tangible order may be passed, so and so. So that the specific averment was made by us. Now this was heard by the office of the Deputy Commissioner, Additional Deputy Commissioner. At page 92, the order was passed on 28/6/2011. Now, my lord, is a small order. If your lordship kindly see on the second paragraph, the father of petition, now deceased late Putu Gogoi, was awarded tenancy right over the aforesaid schedule of land located so and so, has been keeping continuous possession over the state along with his son. After his death by inheritance, his son petitioner has been occupying possessing the land peacefully without any interruption or resistance, any corner observing the conditions of tenancy right. Major parts of the land are being used by tenants for cultivation in small areas, about 2 bighas used for dwelling house. There are no subtenants under them as the entire land of said schedule have been possession occupying by the petitioner. After the death of their father, the original tenants they have as legates and occupiers, then they have every right to set ownership right as per provision. In view of the above, this proceeding has been registered notice were issued to all the concerned and received duly by opposite party engaged learned advocate represented. Now the original recorded partner of Patana 14 was similar Jagada Gohai, wife of so and so, see Kanak Chandra Gohai, all in respect partner number so and so. All are now deceased. Notice were issued to legal heirs of the above original partners accordingly. Seen the report submitted by circle officer so and so, all land document relevant to all examined. The objection petition submitted by learned advocate, allegation objection made through this are not acceptable in case of awarding of ownership right. After considering all facts, I am satisfied and do believe that petitioner, that is occupying tenant, are entitled to get ownership right over the aforesaid schedule of land as provision of section 25. According to hereby award ownership right the first party of instant case, subject to payment of so and so, so and so. So ownership right was declared in their favor. Now against that, my lord, we came up before this High Court. In the High Court at page.
I got a ABR.
At the High Court, then my lord, Somehow, my lord, I don't know, 102, it was fine. High Court
So
said
what
this
is
is
the, what is this 95?
90.
5?
95 is the, I think we, same order,
Why?
the same additional deputy commissioner. It's a type, yes, same, photocopy, my lord.
Same.
Yes, same.
Why twice?
I don't know. I think we twice, my lord, wrongly it has been done. I think the same. Then it came for correction of records of right at page 98. Page 98. For correction of records of right in 2011. At page 98.
20?
8. Additional deputy commissioner has written to the cycle officer for correction of records of right, because 81, my name was recorded by right of inheritance, all the legal heirs. So that was asked to correct in view of the judgment passed by the additional deputy commissioner. And this order was passed on 11/7/2011. Now at page 100 is it translated. The order was passed by the Lotmondal to the circle officer, whereby it was informed.
Correction done.
Yes. This is there. Thereafter, my lord, we moved before the High Court against the order passed by additional deputy commissioner. But it was in a wrong forum. The court said that yes, wrong forum, so you are the liberty to move before the appropriate forum. And so far as delay is concerned, that my lord will be considered by the learned Board of Revenue. This order was passed by this court at page 102, the order of 6/12/2017. 6/12/2017.
One minute. 612, yes.
Kindly see at page 106, paragraph 7. Considering submission of learned counsel appearing submission of the Talukdar reports as under section 67 of the Act, said impugn order ought to have challenged before the Honorable Assam Board of Revenue within 60 days from the date of the original order impugning this petition. The petitioner, without filing the appeal, has moved this petition, which is not maintainable, having not exhausted prescribed forum under so and so. Court grants liberty petitioner preferred appeal before this Honorable Court as Honorable Board of Revenue as per provision of so and so. Shall explain the delay caused owing to final writ to challenge the impugn order in a wrong forum. So accordingly, we moved. It was delayed. Condole was delayed, my lord. At page 108 is the judgment that has been passed by the Board of Revenue, which is now being put to challenge before this honorable. Now, my lord will kindly see what is the finding of the, my lord, I can read the, because this is important. This is not a very big judgment, 2-page judgment. This order has been passed on 19/9/2020. This is an appeal under 67. My lord, second paragraph. The fact in brief is the present petition legal heir of late Kanak Chandra Borgohain, owner of land in question, land measuring so and so, so and so. Response number 2, 3 are recorded priors tenant under the Pattadas owner of this land. Response number 2 and 3 prayed for ownership right and submitted petition along with form number 5 as per provision of Assam Temporary Settled Areas Act 1971 under section 23.
How do you overcome the fourth paragraph?
Which paragraph?
Fourth paragraph, it is relevant to mention.
It is relevant to make another title suit is ordered by Honorable Sir Johra, the response number 2, namely so and so, has got absolute right and title interest position over the suit land. I know that your lordship will put an answer to me. I have got a reply to it. I'll give an answer to it. I have got it. Your lordship wants an immediate answer. I can give it, my lord. My lord, there was a suit. We have got a copy. I also checked. When I read the judgment, I said this will be an order. This question will be put by the court. There is a suit which is filed by one third party against my learned friend's kind, against me. Suit for right title interest over that particular property. Now that suit was decided where the suit was dismissed. Suit was dismissed. Now, in that suit, when it was dismissed, my lord, they also prefer an appeal before the higher court. That was also dismissed.
The third party.
Third party. This is dismissed. So, my lord, your lordship knows the law. There cannot be, if you don't file a counterclaim, there cannot be a right title interest given by a court, either to me or my learned friend.
As a defendant.
Yes, they cannot, unless you have to file. So this is what, my lord, my answer is, my lord. Where is the question of declaration of right title? And where, with great respect, my the learned Board of Revenue relied on that. This is what I have got a copy. I'll give a copy of the order. I just also told my learned friend, you get the copy of that order passed by the learned trial court below. So that is, my lord, we just go to the second. Appeal and agree by order so and so, challenge the order passed by so and so. Appeal before this court, provision of section 67 of so and so. The Honorable High Court is order specifically mentioned before the Assam Board of Revenue. The petition appellant therefore preferred his appeal. The main argument put forward by appellant. Additional deputy instituted and passed an order against a dead person. That is, my lord, the whole and thrust of the entire case. It is my lord, a case which is filed against a dead person. From the inception of the case, this is what the judgment, I will show it, my lord. You cannot file again, it becomes entire nullity. My lord, during the pendency, and there is no chance of substitution of legal heirs. Where is a question of substitution of legal heirs? It is date from the date of inception, my lord. 30 years back, you file and file an application before the additional deputy commissioner claiming that I have a right because my father was acquiring. 30 years after that, you came to the court. So this is the whole, my lord, when we moved the matter, I think there was an interim order. Our whole case, we said that there are 3 points. One point is it is a dead person. The entire law is very clear, my it becomes a nullity. One. Secondly, my lord, if your lordship holds that it can be proceeded against a dead person, it doesn't become a nullity. The second point is that you have to file this application under a proper form number 5 under provision, which is not being filed. If the first point, second point I am saying, my lord. And the third point, photocopy. Photocopy, exhibited, photocopy, he comes up and say this is a photocopy. Photocopy.
Of
Hatiyan, photocopy before the revenue board. Photocopy. Before revenue board, the learned revenue board said, with respect, he says, no, original copy was submitted before the trial court. So we are satisfied. So you may submit a photocopy, relies on a photocopy. And the original suit was before which was dismissed. How can the learned Board of Revenue rely on a case which was suit was dismissed? And the learned trial court proceeded on the basis.
No, suit was dismissed, but in that suit, your adverse party was one of the defendant.
I know, we were also a
No, you are a co-defendant.
Yes,
Now,
co-defendant.
in his defense, he has exhibited the original
Yes.
Hatiyan.
The original Khatiyan, which is the learned Board of Revenue is saying. How the learned Board of Revenue, without calling for a record, with somebody coming and saying that, my lord, when a suit is
Record was not called for.
yes, when the suit, my lord, where we know, my lord, when a suit original copy, his original copy forever it is not retained. It is returned at one point of time. They did not have, my lord. Where is, my lord, our whole case before the Board of Revenue? How
At
can
best, they could have taken a certified copy from the
Yes,
court,
right? That's what.
certified by the solicitor, and say
Yes.
that original is in the court record. This is a
Yes.
certified copy.
This,
That was also not done.
yes, that's why I told my learned friend also that this is, I know your lordship will catch hold of what about the suit part. So that's why I got the certified copy of the judgment. And my lord, our judgment of this court also is very clear. Now let us proceed one by one, my lord. Whether against a dead person, my lord, whether suit can be instituted. Now, my lord, I'll just show few judgments. I think facts, my lord,
Just 2 minutes.
facts is clear, I think, my lord.
Yes.
My lord, first, my lord, I'll place one judgment, not from the Supreme Court, I'll play later on. One judgment of Jammu and Kashmir, my lord, kindly see, I'll take copy. It
Citation.
is 78, but it is reported in 1985. Legal, my lord. Lordship got it? Supreme Court, my. Now, my lord will kindly see paragraph 4, 5, and 6. 3 paragraphs, small judgment. What is the law on it, my lord? I just place it.
Paragraph.
Paragraph 4, 5, and 6. In C. Mutto versus so and so, AR 96 of Mysore, it was held by division bench of the Mysore High Court after review of catalog of authorities on subject. Suit filed against the dead person is nullity and the court has no jurisdictional grant and application so and so. Subsequent to filing of the suit, we are in respectful agreement with a view of the Mysore High Court and find that view of the court received support. Certain observation of Supreme Court of India reported in so and so. In Hiralal versus so and so, the validity of decree can be challenged execution proceeding only on the ground court which passed the decree was lacking inherent jurisdiction in the sense that it would not have cession of the case because the subject matter is wholly foreign to jurisdiction or defendant was dead at the time the suit has been issued or decree passed. Last paragraph. In view of the aforesaid pronouncement of the Supreme Court, the question referred to the earlier part of the judgment was answered in the negative. And it must be held that where a suit is filed against a dead person, it's a nullity. And a plaintiff cannot be allowed subsequently to amend the suit and substitute a legal repress in place of defendant. It appears the observation of Supreme Court were brought notice of the learned single judge where the case was referred.
We're not brought.
Yes.
Not brought.
Yes. Were not brought. Sorry, not brought. So and so, so and so. So this is a small judgment. Now next, my lord. One judgment of the Supreme Court. I'll show 1962 Supreme Court 199. Hiralal Patni versus Kalinath, my lord. (1962) Supreme Court 199. Paragraph 4 after 8 lines. Paragraph 4 after 8 lines.
That was referred to in paragraph 5.
Yes, correct. Just your lordship can just mark it after
Paragraph
4 after 8 lines. Only few lines. The validity of decree can be changed executed only on the ground the court which passed decree was lacking so and so, so and so. That was effort. Your lordship, right? That was effort. Lordship got it, my lord.
Paragraph 4.
Paragraph 4 after 8 lines.
Yes, the validity.
The validity of a decree can be challenged execution proceeding only on the ground. Court which passed the decree was lacking inherent jurisdiction in the sense it could not have season of the case because subject matter was wholly foreign to jurisdiction or that defendant was dead at the time the suit has been issued or decree passed or some such other ground which could have effect of rendering the court entire lacking in jurisdiction in respect of subject matter over the parties to it. Yes. Now, my lord will kindly look into another judgment of Delhi High Court. 1988, AR Delhi 267. Lordship got it, ma'am. Equals are 1988 EIR Delhi 267. After Delhi High Court equivalent citation, the Lordship will find. Lordship will kindly mark paragraph 17, 18, 19, 20. All the judgments was referred. Some few judgment was referred. Kindly see para 20. I have considered the relevant contention of the parties. The contention of learned counsel for Mr. Viswanath Mehta has force and it should prevail. Suit cannot be filed against that person in view of the pronouncement of judgment of Hiralal case and in view of the various other high court relied upon by learned counsel of Viswanath Mehta. And I'm a considered opinion. Suit against the dead person nullity and the plaintiff cannot be allowed subsequently to amend the suit and substitute a legal representative in place of defendant. I fully agree with the reason given in the judgment.
You have read paragraph 20.
Paragraph, your lordship can mark 17, 18, 19, where this certain judgment was placed by the council, and 20 is some finding I have considered. 22 is that 22 minor result is the suit filed by plaintiff and a dead personality, and the same is dismissed. No order as caused.
Yes.
Now there is the judgment of Mysore High Court. We find less judgment of Supreme Court, some few judgments, but High Courts mainly we find. 1963 minor, the CC online. This is Mysore High Court. This was referred to a division bench as an important question was raised, my lord. First paragraph, kindly see, my lord. In the revision be directed against the order so and so has been referred to a division bench by one of the us as it raises the important question whether a suit brought against a person who is later discovered to have been dead at the time the suit was filed can be amended by substitution another person is defended. Now your lordship will find at paragraph 6. He would in Mohan Chandra so and so, who delivered the judgment of this bench held that court has jurisdiction, have no jurisdiction to decide the suit filed against dead person. It is a nullity. This decision was followed by Madras High Court in so and so. It does not appear to have ever been suggested. Issue a writ against a dead person could be anything but a nullity. And we see no reason for regarding the presentation of a plan, which under our system correspond to the issue of it as anything more. Now, your lordship will skip over. Kindly go through paragraph 9. Last on the top. From the top, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 12, 13 line. 13, 14, 15, 16, 17, 18, my lord. There is no direct decision. There is no direct decision of the Supreme Court on this point. But some observation on the Chief Justice in Hiralal versus so and so. The only ground on which the decision of the High Court is challenged is that suit instituted on the Oriental side of the Bombay High Court was wholly incompetent for want of territorial jurisdiction, and that therefore the award that followed on the reference bill between the parties decree of this court under
Irana, you have already read.
that's yes. Paragraph 10. Paragraph 10. It is thus clear that a suit filed a petition of a dead person was a nullity and that the learned subordinate judge was perfectly justified. Suit on the ground, respondent could not be substituted in the place of an original defendant who was dead on the date of presentation of the suit. We do not find any good ground to interfere the order passed by learned subordinate judge. So on the same line, my lord, I'll just one Odisha High Court judgment on the same line, paragraph 6 and 7. On the same line, Odisha High Court at paragraph 6, my lord. Again, Hiralal has been, I'll not read that, my lord. Again, 6, paragraph 6. It reiterated the judgment of Supreme Court of Hiralal. Just to show your lordship. And on paragraph 7, the authorities on the above, suit filing a debt by nullity and no substitution can be. At para 7. Court. Now, one judgment kindly see, my lord.
Yes.
Same, on same ground. If your lordship kindly turn to page 582, this is MP, Madhya Pradesh, my lord. 2072 MP, MPLJ. On page, second page, if your lordship turn to second 581, on the left hand side on the top, 272 MPLJ. Kindly turn to page 582. The decision was followed by so and so. In the case, Mullah J observed, thus, if he, defendant, dies before the suit and the suit is brought against him in the name in which he carried on business, suit is against a dead person and it is a nullity from its inception. That the suit being a nullity, a writ of summons issued in the suit by whomsoever, except it is also nullity. So, my lord, summons is also becomes a nullity. Forget about the judgment. That is why our objection was very clear.
Paragraph?
This is 582. If 582 on the top, 582.
Yes.
If he defended, the decision was followed on the top, second line.
Yes. Yes.
Decision was followed by so and so, so and so. If he defendant dies before the suit, lordship got it, and the suit is brought against him in the name in which he carried on business, the suit is against a dead person, dead man, and it's a nullity from its inception. This word is very important. Now, furthermore important, the suit being a nullity, the writ of summons issued in the suit by whomsoever accepted is also a nullity. Similarly, any other made in the suit following allowing amendment of the claim by substituting a legal repentive or decease as different allowing the suit to proceed against him is also a nullity. It is immaterial. The suit was brought bona fide and in ignorance of death of such person. So it's very clear from his inception. And his summons issue also becomes a nullity. That's our whole case where we move this matter. Immediately there's some interim order was passed. We don't have to go to other points. Your lordship raised that point. How do you overcome about this suit? But this is a point, my lord. And suit, my lord, the judgment is there if your lordship want to see. And again, that's very important, my lord. Photocopy. Photocopy, there is one judgment of the Supreme Court. It cannot be admissible. Your lordship knows that law is very clear. Any photocopy cannot be admissible in the evidence. How the learned Board of Revenue, this point I want to cover up on this point. 2009, 6 SSC 681. My lord, kindly say para 9.
9.
Yes, para 9. Para 9. Respondent number 1 claims himself to juvenile. Enquiry was directed to be conducted. In the said enquiry, evidently, the original register maintained by Government Secondary School, Navanagar, was produced. Date of birth of the said respondent was stated to be on 10/2/1987. Before us, a contention was raised as to whether column 5 therefore thereof was filed up or not. The affidavit was filed to show column 5 is a statement on the declaration of the father. We would therefore proceed on the said basis. Respondent 1 was admitted in Government Secondary School, Navanagar on 22/1/1996. He left the school on 31/12/1999. Certificate was issued on 23/3/2000 so as to enable him to take admission in another school, namely Ram Lakhan Singh Yadav High School. We may not consider the certificate granted by principal later school, as only a Xerox copy thereof was filed, inasmuch as the original having not been produced, same was inadmissible in evidence. It's a fact. That's what is, my lord. We don't produce the original. So this finding of the learned Board of Revenue, I think, my lord, we heard. First, my lord, this suit, he relies on this suit. He relies on this suit, my lord. Now, suit is filed by some third party. This I give the judgment to your lordship. The suit was filed by a third party where my learned friend was made a party. I was a performer. Suit was dismissed. My information is the appeal was dismissed. Appeal, copy of the appeal is also being produced. Copy of the appeal. The judgment I am just producing before this court, my lord. Now, how right title? Kindly see the observation of the learned court at 109, my lord. This is one judgment I will show, my lord, of the how a right title interest can be shown, can be given by a court. Kindly see paragraph 9, my lord. Take on judgment. Put this, appeal this. Lordship got it.
Page,
This judgment, para 8.
that was in the last part.
Yes. 8, paragraph 8, Lordship has seen of the judgment of this court.
No,
Oh,
I
I have.
the suit.
Here. Put a line of copy. One copy it was there, so. It is written there. It's.
Yes.
Now, let's see one judgment of this court. Where is if you don't make a counterclaim, there is no question of giving the right.
Just let us have a look at the second appeal.
Yes. Yes. 103 or 1958. Lordship will look in second appeal. 98, my lord.
But who are these
No,
Gojan
these are
Burwa?
not. I am showing my judgment.
No, what is Gojan Burwa, Jyotish Burwa?
No, this is, I am showing my judgment of this court, not related to this.
No, you said that you said that appeal was also dismissed.
This is appeal, this appeal. What is the fate of that? I don't know. High court position is second appeal.
No, you said that appeal was also dismissed.
No,
That
appeal,
is not, this is a different appeal.
No, this not that. What I have shown to this court.
Understood?
Title appeal.
Yes, title appeal is not there.
I know what, just now I have given my.
That is understood.
Just now I have just given.
First, we have got title suit by Gobind Prasad.
Yes, yeah, that is a suit.
That is the suit which
Yes.
was dismissed.
Yes.
Dismissed.
Appeal, that's why instruction, I don't know what has happened today.
So you had initially said
No,
the
no,
appeal was
yes,
also
sir.
dismissed.
Suit, my lord.
But the suit was dismissed, that you have.
That will appeal is in my opposition lordship, page number 31, annex 3,
What
lordship.
has happened there?
Evidence and affidavit, lordship.
No, what has happened there?
There is a appeal the judgment of the civil court, lordship.
The dismissal of the suit has been upheld.
Appeal, lordship.
Okay. And now this is a different altogether
Yes,
citation.
yes, this is a
To bring home which submission of yours?
paragraph 8.
In support of which submission of yours? Photocopy, okay.
But there's no, sorry, my lord, that's a co-owner where you cannot declare, you cannot give a right at an interest where you doesn't claim for in a counter claim, co-owner. At paragraph 8, my lord.
Paragraph 8.
Yes.
Essay 103,
Yes,
98, order dated 11/8.
yes. Paragraph 8.
Yes,
However, this court has noticed that by impugned judgment dated 8/5/98, learned court below has declared the right title interest of the defendant one as a co-owner over the suit on the basis of the purchase claimed to have been made by him by a sale deed dated 21/9/84. Mere dismissal of the plain claim in the suit would not automatically result in a declaration of a defendant claim to the suit land. The defendant one has not set up a counterclaim in which any declaration has been paid for. In the absence of a counterclaim by the defendant, it is incomprehensible as to how any declaration could have been made in favor of defendant one in the suit. Consequently, declaration of right title interest defendant as a co-owner is made by learned appeal set aside.
okay.
So now, please now kindly see 109, my lord. Kindly see the observation of the learned Board of Revenue. Page 109 on this issue, my lord. On this issue, 109.
That's the. One zero?
109. 109.
Yes,
On top, after 3 points, 109, 1, 2, and 3.
Hmm.
Respond number 2 and 3 has filed written argument affidavit opposition also put forward oral argument to the counsel. Content of response is that appeal is barred by limitation appeal is filed with a delay of almost 8 years.
Hmm.
Respondent side also argued that Honorable Muslim Court dismissed a title suit number 63 of 2011 filed against respondent
Hmm.
where the appellants were performer defendant by the judgment dated 5/9/2014. Further, respondent side also argued that in another case filed before this court of civil judge Jorat in title suit, the honorable court has got absolute right title and possession of the respondent number 2 and 3 in the judgment dated 30/11/2015 and dismissed the title appeal by 15%. The civil judge thus upheld the judgment and decree passed by learned Munshi Jorat in title suit number so and so. The records on file shows learned Munshi meticulously gone to the records presented by the respondent and thus convinced the regarding tenancy claim of the respondent number 2 and 3 of the case. Heard both sides. I have carefully gone through the record, examined the argument put forward. As far delays filing the appeal is concerned, delays filing of the appeal is wrong forum. The appellants examined the delay and also for taking on record office of deputy commissioner on being satisfied. Delay is condoned. I have carefully, this is a finding, my lord. I have carefully perused the order of learned additional deputy commissioner Jorat, wherein it clearly mentioned notice was served on the legal heir of their deceased Patadar, which is examined as a part of available record. Legal heir of the deceased Patadar also appeared through their counsel in this case. Hence, the argument in the order was passed against a dead person does not hold good. I have also perused the argument put forward relating to photocopy of Khatian submitted, etc. And finding that this argument do not hold as there is clear indication. These documents, the original were perused and found acceptable in title suit in the court of Munsif. Argument put forward by appellant regarding non-application of tenancy in proper format and is also a matter of consideration of default because such forms may not be available in appropriate offices when required by applicants and the applicant for tenancy right, which also include the response number 2 and 3. In the instant case, may not be then a knowledge to file application for tenancy in the format. The fact remains response applied for tenancy right to appropriate authority and the authority accepted the same. Further on perusal record, report of circle of a reveal are possessing the land by cultivation for long years. As for records, both the respondents are recorded occupants tenancy entitled to get ownership right after paying due revenue to government. These examples cited by appellant regarding rulings reaching honorable court do not find any central relevance in instant case of actual metrics. 2 and 3 are the right full tenants of the said plot of land and their continuous possession of the same established. So, my lord, on this count, we are before this honorable court. The main point is against a dead person, entire case proceeding dead person. And that was my special objection, which I made. Lordship will kindly see my objection. How against a dead person? If that point is decided in my favor, then I don't have to go to the other points. That my learned friend satisfied that against a dead person also it can be. That's my humble submission.
Yes, Mr. Bar.
May I, Lordship? I have already filed a affidavit in opposition, Lordship. Your Lordship may kindly annex a page
Your
number
four
20.
numbers.
That's number 4 and 5, Lordship. I have filed in affidavit, Lordship.
Okay.
Lordship may kindly go, Lordship may kindly see page number 20, annex A.
Your affidavit is 20, 21, 12.
Lordship. Title suit number 68 to your 11, Lordship.
Page
20, Lordship.
Page 20.
20, annex A. I have enclosing with my affidavit in opposition, Lordship.
Yes, that we have seen.
Lordship.
That was the one copy was placed before this court.
Lordship. The plaintiff number 1 to 15, Lordship. They are the plaintiff, Lordship, third party. We are the principal defendant 1 and 2, Lordship. Next page, 3, 4, and 5. Now petitioner, Lordship. Former defendant, opposite party.
Yes, yes. 3 and 4.
3 and 4, Lord. 3, 4, and 5.
5 why? Biswajit Karmakar.
I don't know, Lordship.
He is not the petitioner, I think.
No.
No, here is not petitioner, Lordship. Lordship may kindly page number 24, judgment of the title suit.
Yes.
Paragraph 13, Lordship. May I read it, Lordship? He also, that means PW1 also stated that original owner Konokchandra Buragohai told him to file a suit and he bore the entire cost for filing the suit, that he does not know content of his evidence on affidavit. That is polluted case, Lordship. And present petitioner and the plaintiff of the original suit, Lordship. Page number 25, he appears there, top of the judgment lordship. They does not know much about the suit land. From the evidence in further reveals that suit was filed by the plaintiff as the instigation of the original owner, Konok Chandra Buragohai, and bore the cost of the litigation. 25 page, top of the judgment lordship. Para number 16 lordship. They applied for declaration of ownership right before the additional deputy commissioner, Nitananda Gogoi, and by us lordship. In TSA 5 2020, ownership right over the entire land was declared in their favor. Declared in our favor by the additional deputy commissioner lordship. As per Khotian, 2, 3, and 4, Khotian number. Exhibited 4 in order passing so into. That is further stated that terms of the order payment of revenue, their names were recorded as a owner of the Javamundi. The Javamundi exhibit 5 and 6, only exhibited before the landed court below lordship by us. Therefore, this title suit is dismissed. Page number 36, lordship. Title appeal number 9, 2015. Filed by their plaintiff lordship. 36. Page number 36.
Yes.
Appellant Gomin Poja, Gopal Poja, Anil Pojan, plaintiff lordship, and principal defendant Nitananda and Debesor, and Sobesor, Debesor, and Biswajit Kumar, performer defendant. After the judgment of the title suit lordship by appellant. After that, we have filed a petition before the
Title appeal has been dismissed.
lordship.
Page.
Page lordship 36. 11 portion is lordship. 38 lordship. Appeal is dismissed, lordship. Mayor lordship 38.
We have given the decree only.
Lordship.
Doesn't matter.
Lordship. In connection is the dead person lordship. Lordship. In connection with the dead person, they are already appeared, file objection, and proper adjudication goes, record was corrected, lordship. Order 1 rule T says, who may be joined as defendant, lordship. Order 1 rule T. Any person may be joined in one suit as defendant, lordship.
This one.
Lordship. Order 1 rule T, lordship.
1 minute. Order 1,
Rule T, lordship.
rule 3.
Lordship. Can I read, lordship?
Just rule 3. Who
Lordship.
may be joined as defendants.
Defendant, lordship. All person may be joined in one suit as defendant where any right to relief in respect of or arising out of the same act or transaction or series of act transaction is alleged to exist against such person, whether jointly, severally, or the alternative, etc. This is also they are admitted is not a okay, the dead person, but a legal here received the notice, appear, file objection. What the illegality, lordship? They appear, file objection, engage counsel. I've been support my lot of judgment also, lordship. Photo dia ekhan dia. 2014 5 GLT 704.
But did you take any step to substitute the dead persons by the present petitioners?
They have already appeared. I am the son, I am the daughter,
They had appeared and raised this objection
Lordship.
that this proceeding is instituted against the dead person.
As per rule 1, rule 3, they are
Now-
admitted, file, I am the son, I am the daughter, I am the so and so.
No, that is
That the
okay.
court
but-
order to me is a substitute.
No, it-
They already appeared,
no,
Lordship.
it is not, it doesn't depend on the understanding. It depends on the requirement of law.
Lordship.
Law requires that if the right to subsist, then
Substitute may be.
the persons to whom the right has accrued, he or she needs to be made a party.
This is Lordship beneficiary legislation, 1971, Lordship.
No, did you take any steps to substitute the present petitioner?
Applied, but maybe, I don't know, Lordship, maybe file a
No.
petition or honorable learned.
No,
Deputy
maybe will not arise because the judgment is in the name of persons who are not there.
There, Lordship.
Now, was there any embargo on your part or difficulty not to implement the present?
Already they are willfully appeared before that court, Lordship.
Somebody coming before the court, it's not a question of, it's a requirement of law.
Lordship.
I may have some interest in the court. I may go there, I may not go there. If I'm not party, it's not mandatory for me. But going there and saying that this is the objection I have, you're trying to touch property which is,
Lordship.
I am interested.
Received notice by their legal heirs, Lordship. Received already received there,
They are not denying that.
Lordship.
The point which in the objection they have raised, their first point they have raised that this proceeding is against a dead person.
Lordship.
How do you go ahead?
They are willingly they appear, Lordship. I am the son, I am the daughter of the so and so,
That they are not denying.
Lordship.
But without following the requirement in law, can you proceed? What are the judgments you would like to rely upon? Let us see. We have understood your contention that since they have appeared willingly,
Lordship.
they have not suffered any legal prejudice. They have
Yes.
defended the case. That is what you want to contend, isn't it?
Lordship.
What are the judgments?
That photo now. Lordship,
give the
2000
citation.
2007 T GLT 489. Ram Pyari Sohan and another Lordship Shankar Goala and others. Yes, please.
Himmat Singh ka Motors,
Lordship. Paragraph 12, Lordship.
2014,
5 GLT 704.
5 GLT 704. Himmat Singh ka.
And
Paragraph
12, Lordship.
12. 12,
Lordship. Am I in, Lordship?
please read. You have a copy?
Lordship. I have a copy, Lordship.
Yes, please.
The next submission of the learned counsel petitioner is that the notice issued to the petitioner did not contain the next date for appearance. This is the next date, Lordship. Facts in different. Even the notice was served on the petitioner. The said notice admittedly contained the case number in as much as the said notice has been annexed to the writ petition as well. Thereafter, the writ petitioner appeared before the land additional deputy governor paying for time and under the such circumstances once notice was served. Petitioner became aware of the case number and filed application before the authority. That means legal heir aware of the fact and appeared and filed an objection, Lordship.
Here, it is only with regard to the date not be given.
Lordship. The basic purpose of notice to make the potada aware that the proceeding was going on under section 20E of the Act. If the said purpose is served and potada appears before the authority only because the notice does not contain details cannot be shared. This is the objection filed by the client senior counsel.
No, we will definitely
form
Must
number,
consider this, but you have to address on one point.
Lordship.
This was no doubt a proceeding which has initiated from the 1971 Act.
Right,
And 23 gives you a right.
Lordship.
And here, incidentally, the proceeding was against the existing pattadar.
Pattada,
In the instant case, it was not the against the existing pattadar.
Lordship.
It was against the person who has already passed away some long years back. Their names have been have entered into the records of right. They were not made parties. Here the case is that proceeding was made against the existing pattadars. The date was not given in the notice. And thereafter they had also come to the court. The court has said that will it make any difference? There is a vast distinction because the respondents here are the pattadars. And in the case which is in the hand, our hand, we are deciding, the
Lordship.
pattadars were not parties.
They are not Patadel. Already they have their name as Cattle, name as but mutation and revenue received. Revenue issued, revenue paid by 2009 and 10, from the 10 and 9. Well,
Now,
so
when did they, when was their names corrected? After, on the death of the original pattadars?
81.
A long time back. And when did you come for, when
Jamabandi
did
Lordship.
you invoke the 71 Act?
2010.
2010. In 2010, whose names were there?
2001. I have it in hand, and my father was a Khotian holder.
In 2010,
Lordship.
whose names were there in the patta? The petitioners or their fathers' names?
My father name.
No, not you. Your name has come only under the 71 Act. Prior to that, before correction, before procedure,
My father was a occupant, Lordship.
you said that your father was a riot.
All right.
But who was the owners of the land? Whose names were there under patta?
Petitioner was the owner of the land.
But you did not file a litigation against him. You had put the name of his father or their ancestors.
Here.
Okay, what is the next decision?
Lordship. 2005
Rampiari.
Lordship.
Hmm. 2007 3 GLT.
Lordship.
Which para?
Para 9-11, Lordship. 9 and 11, Lordship.
9 and 11.
Lordship. 2007 GLT 489. Wait a minute. Lordship.
Please read.
Para number 11, Lordship. May I read, Lordship?
Please.
In the face of the fact that Khotian issued by the revenue authorities was brought on record as Exhibit 1. Let's see, Khotian 2, 3, and 4. On honest days, on the contesting defendant showed that the Khotian was not obtained in accordance with law and that entries made therein were incorrect. In this regard, the contesting defendant entirely relied on the observation made by the learned additional deputy commissioner. While dealing with the contesting defendant application for partition of suit land, mutation of their names and owners of the suit land. The contesting defendant application was for mutation their name as owner of the suit land. Present plaintiff had no locus entity to oppose the same investment. He was a mere tenant and her only possession of suit land. Observation made by the land and additional Khotian had not been properly issued. That is the Khotian, Lordship. Question of Khotian. And another question is, Lordship, mutation entity does not and right title and impact of the Lordship. Supreme Court said letter 2021 Lordship online SC 802.
Where reading? Is the part of the judgment? No.
No, sir, online Lordship.
What is the proposition?
Mutation entity does not confer any right. Lordship.
There is no dispute. That is the established law.
Lordship.
That does not, no title accrues upon anybody.
Lordship. Our High Court also read petition number Lordship 660/2010 and read appeal number 295/2016 Lordship.
But Rampieri, for what provision you have relied upon? Which point of yours?
Lordship, wrongly I have submitted this.
Huh?
Rampier is not relevant in this statement.
I don't think it's too much relevant. Next.
Read appeal number Lordship. Our court Lordship.
Yes.
295/2016, para 5. This appeal arises Lordship WPC number 660/2000.
Bikram Fukan.
Lordship.
Okay, we'll come back after lunch. Any more judgments? No.
No.
Then you have to address on two more points,
Lordship.
which is urged by Mr. Das. And Mr. Das, in the rejoinder, would like you to address on the 71 Act also. Mere filing of an application, will it be enough to give the
No.
rights to the riots? What are the criteria? Is there any time limit? And against whom it is to be filed on those
Yes.
71 Act?
Yes.
Anything, Mr. Tiwari?
After this case, of course, Lord, my prayer would be for upgradation of item 28, 21. Lord, that very case of Subhansiri project. Construction of the-
Amendment case.
I'll inform the lawyers of the other side.
If there is no objection from the bar, we can.
Subject to, I'll request my friends and of course, the lawyers from the other side also will have to be informed. I'll tell them.
Mr. Chaudhary is there.
Mr. Chaudhary is there. Mr. Bora is also there. So
Yes, yes.
whosoever is
We'll
available.
try to have that matter. It's an important matter.
Yes.
Amendment has been
Yes.
put to hold, isn't it?
Yes.
And I don't think that will take much time. Other side, if you have no problem, if there is no urgent matter, we'll take up your matter.
Very well.
So, Bora, you are referring to Bikram Fukan.
Lordship.
Which paragraph?
Lordship. May,
You are referring to Bikram Fukan. WA 295.
Lordship.
Which paragraph?
Yes, sir. Clarification. Lordship, by instruction from my client, the form number 6 is applied before the ADC in the name of the dead person. After that, ADC decided when the legal heir of the entered the suit, that then title of the case is by legal heir of the name Lordship. Firstly, by the dead person. After that, case of the title is Nitananda Gogoy and Josuda Gohai, Connection of Gohai. And after that, they are entered the base of Gohai.
Where do you find?
Instructed by my client,
No,
Lordship.
that is not enough.
Lordship.
It has to be there on record.
Lordship.
First, let us finish your argument. You had relied upon Bikram Fukan's case. Which paragraph? 295 WA?
Lordship. Bikram Fukan, Lordship. 9, 10, and 18 and 34. 9, Lordship.
9.
9, Lordship.
Having considered,
Lordship. $18, Lordship. And 34, Lordship.
There is no 34. There are only 10 paragraphs in Bikram's Khan.
10 paragraph, Lordship.
10 paragraphs only.
10, Lordship.
And the other one, there is a writ petition also. Okay,
Lordship.
okay. In writ petition, which paragraph? No, we'll go by the appeal since there was an appeal.
Lordship.
We'll go by the appellate court judgment.
Lordship.
Okay.
Paragraph number 5, Lordship.
Page what?
Yes, Lordship.
Which decision?
Paragraph number 5, Lordship, page number 3.
Which decision?
Writ petition, writ appeal number 295, 2016,
295.
Lordship. Bikram Phukon.
We have read 295.
Bikram Phukon, Lordship.
295, we have said paragraph 9. We have read 9.
Yeah. And 5 also, Lordship. Telling the review order passed by the revenue board. Paragraph 5, Lordship.
5, what is the law point involved? Nothing?
Lordship.
Five, there is nothing. 9, of course, there is the question of notice.
Notice, Lordship.
9 we have considered.
Lordship, no, আছে দাদা? Yes, no? Affidavit. মই দিয়া। এই বইতে আছে।
Yes, anything else?
All right. Order.
Yes, yes.
Lordship.
What is the next point?
Order 22, Lordship. Rule 4, Lordship. Rule 4, sub-rule. Sub-rule. 4, Lordship, may I read?
Please.
Order 22, Lordship. May I read? Procedure in case of death of one or several defendant or sole defendant, Lordship, where one or two or more defendant dies, the right to sue does not survive against the surviving defendant or defendant alone or sole defendant or rule sole surviving defendant dies. The right to sue survive. The court on application made in that behalf shall cause the legal representative of the deceased defendant to make a party and shall proceed with the suit. 2. Any person to made a party may make any defense appropriate to this character as legal representative of the deceased defendant. This is also logic.
Any person so made a party. The condition precedent that that person has to be made a party.
Logic.
Did you make him a party?
Firstly, they came two person make it as defendant lordship. After that, third party come. After that, with petition, there were so many petitioners. Revenue board only 2 petitioners. When appeal is placed before the revenue board, only 2 petitioners there. Now this with petition, only petitioners are 5.
Where is the order of the revenue board?
Revenue board page number, lordship. Main writ petition, page number 9, lordship. Or 108.
Twenty-four is the application.
24 another.
Application. Before the revenue board. Twenty-five is the cost item, 5. Here also we are 5.
5% are there.
Lordship. An objection filed by the only 2 petitioners before the ADC lordship, page number 90. Tobeswar Buragohai and Deveswar Buragohai. Page number 90, petition lordship. But appeal file 5 petitioner lordship.
See, you are the respondent in this case.
Lordship.
As a respondent, you could have raised this objection in the appeal before the ABR.
Lordship.
Did you raise this objection? Was it decided? You have not even raised this objection. It is deemed to have been raised and rejected. That is the law. Here is a respondent in this proceedings. It is not, it will not be open for you to raise that issue. You could have raised this issue before the ABR. That they did not file any objection in the before the ADC. How can they file an appeal? It was not an issue raised.
Lordship.
You address upon the other 2 questions. We'll close this. There are 2 other issues. That in the suit, which was filed by the third party, which was dismissed,
Lordship.
thus dismissal of the suit amounts to a kind of a decree confirming right title and interest of the defendants.
Lordship.
He has also relied upon a judgment.
Right title is not declared by the learned court below Munship Lordship.
No, but
But
there
this is just-
is an observation
Observation Lordship.
that right title and
Right,
interest has been declared in your favor.
Lordship.
So is that observation correct? He's assigning that observation.
Right.
And the third is that photocopy.
Photocopies,
Three issues.
photocopies are only exhibited in the learned code below, Lordship.
That is in the code, in the civil code. What was, did you make did you apply under the proper procedure to call for the records or get a certified copy of the records from the civil code?
Lordship, revenue board record, maybe? I think,
No, not the revenue board's record. In the revenue board, you had relied upon a photocopy.
Lordship.
You said that the original is in the civil suit. Did you make an application to call for the records of the civil code, number one? Or even to the extent of having a certified copy of that particular document?
Lordship,
Did you make that endeavor?
Lordship.
Apparently, you have not made that endeavor.
In the revenue board order already reflect this, Lordship. The civil judge, the judgment dated him dismiss the so and so, appellate judgment so and so. The records of files show that there may be records may be available in the revenue board, I think. That time,
Which page are you reading?
109, Lordship.
109. Let us see. Yes. Which paragraph?
Top, Lordship. Respondent number 2 to file
Yes.
and below, Lordship.
Mhm.
The records on file show that learned Munship has meticulously gone through the records.
That is not the finding regarding the photo that particular
Question.
document.
Lordship.
That is a normal general observation. See, regarding photocopy, there is a discussion.
Lordship.
At paragraph, if you count from below, in the same page, 1, 2, 3, 4, fifth para, I have carefully, have you seen that paragraph? The paragraph starting with the sentence, I have carefully perused. In the middle,
Lordship.
please read this. Please read this for us.
I have carefully perused the order of the Land Additional Deputy Commissioner Juhat, when they clearly mentioned that a notice was served on the legal heir of the deceased potterer, which is examined, is part of available records.
Yes.
The legal heir of the deceased potterers also appeared through their counsel in the case. And the argument of that the order was passed against the dead person does not hold good.
Yes, next.
I have also perused the argument put forward regarding photocopy of the Kotian submitted, etc. And find that this argument do not hold, as there is clearly indication that this document is original, where perused and found as acceptable in the title suit number 63 of 2011.
This is the observation we are concerned
This
about.
is the observation.
He relied upon
Title suit.
the findings of a title suit wherein this document was produced. That was in a different suit.
Lordship. Lordship.
To rely upon the same document in another proceedings, he has to have a look at the document, the original document, if not the original, certified copy, duly certified by the registrar. At least as a secondary evidence.
Lordship.
These three questions we have to determine.
Lordship.
First is against proceeding against that person.
Dead person.
Number two, the Khatian was not produced, was not proved in original.
Lordship.
And number three, the issue of the observation that in the title suit, the learned ABR has come to a finding that as if the civil court has declared right at an interest of the defendants.
Defendant. Lordship, kindly allow me.
No, we are concluding this. We'll consider what you have said. We'll consider, we'll have to give you a thought. Yes, just
to know it.
yes, on the tenancy
I
Act
just
of 1971.
really look into the tenancy act.
Come
I'll
on,
just give a copy which.
come on, 1971 tenancy act. Tenancy Act 1971.
I got two copies.
No.
I think that will, I
And
got,
this-
yes. First, look into the act.
That's correct.
First would be Assam Temporary Settled Area Tenancy Act 1971.
Yes, please.
Lordship will see section 23. Acquisition, section 23.
Yes.
Acquisition of ownership right and intermediary rights by tenants.
Hmm.
Any occupancy tenant personally cultivating the land of his tenancy desires of acquiring the ownership rights of his landlord may at any time make an applicant writing to deputy commissioner, and on such application being made and compensated as provided in section 25 is determined and paid by the occupancy tenant, deputy commissioner shall declare the said occupancy tenant to have acquired the ownership right free from all encumbrance. So this application has to be filed under section 23. Now, your lordship wanted to know that what is a procedure like? The procedure your lordship will find in the rule, the Assam Temporary Settled Area Tenancy Rule 1972. Kindly see Rule 9. Rule 9.
Disposal.
Application for acquisition by tenants, Rule 9. You have to file an application.
Yes, yes.
23 you are claiming, but application has to be filed
Hmm.
in this format. An application for acquisition under section 23(1)
Hmm.
and 23(2) shall be in Form 5. And it must be signed and verified by the applicant.
Hmm.
Now, if you look into it, Form 5, kindly see Form 5 here. Because there is a meaning to it. Why Form 5? Because kindly see Form 5.
Hmm.
Which we have annexed in our petition also.
Is there?
Yes, we have annexed it.
Is there? For Form 5 we have seen.
Yes, Form 5, like kindly see, and which was annexed in our petition also. Last page 110
Hmm.
for the convenience of the court.
Hmm.
Now, this application has to be filed at page 110.
Hmm.
And this was not filed, which was mandatory, because there has to be a verification. Now, kindly see his application. His application, the lordship will find page 47, 74 his application. His application is page 74.
Hmm.
Page 74. This is his application which he has filed. Where is the name of the landlord? And his address at page 74. কট্টন করি রায়তির নামত পত্রটা দিয়ার আবেদন বিষয়. So it was not in the procedure that has been laid down under Form 5. This is one of the ground. There is not been.
No, even if we strictly do not go by the format, but we have to go by the contents.
Yes,
It requires a verification.
this is what.
There is no
Correct,
verification.
right. Well, it is suit, my lord. Verification is required. There is no verification. So this is not there, man.
Let us see the contents again.
At page 74.
মাননীয় উপায়ুক্ত মহোদয় শ্রী নিত্যানন্দ গোয়েন নিবাসী বিষয় নামৰ মহোদয় নিবেদন তফসিল তুমি Okay.
So my procedure is laid down. And more so, I have been instructed, and kindly see at 13, rule 13. Rule 13. Publication of declaration for acquisition. As the compensation amount is deposited by tenant as per order Deputy Commissioner 12, shall public declaration forms in official gazette within 30 days. All this was not done. It is apparent how an order is passed at page 100. All this is not done also. And your lordship knows under the Evidence Act also, presumption has to be drawn as a document, 30 years old document, the 19 of the Evidence Act. So that presumption will be in my favor. 30 years, 81. That also is in my favor. Presumption has to be drawn as section 90 of the Evidence Act. The core issue is against a dead person. How it can proceed. And the procedure has been laid down. In what manner? Simply by filing an application will not do. Verification has to be there. In a suit, my lord, verification is mandatory. So this is my submission, my lord.
Okay.
The order.
Heard Sri D. Das, Learned Senior Counsel, assisted by Sri T. G. Purva. For the petitioners. Also heard, yes, anything, madam? Nothing. Both of you are there. And you? Also heard MSM Burman Learned State Council, as well as MS G. Hazarika Learned Standing Council Revenue Department. Full stop. Three. Kiarbora, right? Kiarbora Learned Council has appeared for the as per numbers
4 and 5, Lordship.
4 and 5. The argument, the hearing is concluded and judgment is reserved. The LCR has been received. Hearing is concluded, judgment is reserved. Okay.
Highly Lordship.
There is one item 11 and 12. I think
One item, Mr. Tiwari is trying to
it
upgrade.
can be, my lord, if your lordship is not inconvenient to my learned friend.
It takes some time, madam.
Which one? 11, 12.
11, it takes some time, madam.
They will, they have filed.
Any date, madam?
You request for a date? Depends, where Mr. Tiwari is your other side?
They were informed. I was also told that there is a special bench. And they have some case over there, but Mr. Bora possibly is free. I don't know, of course. Mr. Bora was also informed, but neither of them
Bora tactfully will not come.
naturally will not, is understood, my lord. Once the interim order is there,
That is the minimum tax. Not to be seen anywhere near.
my lord, I'm one person, my lord, I hate to ask for ex parte.
No, we had an accident for your upgradation. We could have done it. And this matter we had taken the earlier occasion, so it's fixed today
Yes.
for disposal.
My lord, could it be, my lord, then on Thursday at least? my lord, after the motions immediately higher up in the list.
Yeah, that was the understanding even today.
Yes.
But if Mr. Chaudhary is stuck somewhere, then let's try day after tomorrow.
Thursday.
Anyone with Mr. Chaudhary? Ken Chaudhary?
Possibly,
You asked.
actually, that is why. Mr. Chaudhary is busy, I know.
No,
That is-
Thursday, is he there in Guwahati or not?
I,
Just get the date, we'll fix on Thursday.
sure, my lord. Thursday, huh?
Mr. Bothapur, you can have your case today then.
My lord, on 9th, my lord. 9th. I have to.
He's tired, he's tired.
Old.
You are not old.
And Mr. Das will not, Mr. Das told me that he will take only 10-15 minutes. But as it transpired, my lord, since morning, once his case
10
began,
minutes,
he
10
continued.
minutes. I told you after recession, 5 minutes. On 9th, I requested my lord. 9th.
Okay.
Subject to your continue. 9th.
But you are not looking tired at all. I've never seen you looking tired. And I hope you remain like this. Okay.
Deeply organized.
What a date, 30
9th.
9th. Which matter? Item number?
11, 12 and
11.
11 and 12. On the request made on behalf of the petitioner. Placed on 9th of
9th. 9th of May.
9th May. This court may not be there on 9th.
Any date which you
No problem. Some other court would be there. We can like that. Should we fix it day after tomorrow? Just get the date.
Better, my lord, yes.
Just have his availability. Send some for junior.
And my lord, kindly at least higher up in the list so that, my lord,
Higher
Thursday.
up, that cannot be because it comes in chronology. What will accommodate you?
My
Make a
lord, then in
mention.
the morning itself,
You
I'll
make a
mention.
mention. Make
I'll
a
make a
mention.
mention in
But
the morning.
get his availability on day after tomorrow. We'll
Very
pass
well.
the order then.
Well.
You may not go ask send off something for junior. Just sit for a while. Yes, thanks, Meta. Nine and 10 to Nala, na? 9 and 10 to good. Oh, yes. Oh, it was Belek matter. 11 and 12. Yes. What is this?
Lordship here, affidavit is yes, yet to be filed by the respondent. Lordship.
Which respondent? You'd like to file some affidavit, Mr. Puchi?
Notice has been issued on 16 to.
Mr. Aludar? You'd also like to file affidavit. No, nobody has filed affidavit. On a prayer made on behalf of the respondents, matters stand adjourned by 3 weeks to enable filing of affidavit in opposition. Is there any interim order?
No, Lord.
Okay, next. 19th. One, three.
Matt, please.
Yes.
Well, there is a way. What's it called an interim order? Very cleverly, they have subtract the order. Lots of people.
Yes, FCI, who's there?
Say, my lord, he submitted last occasion, tenancy order that is 24/23.
In the IA.
In the IA, my lord, your lordship will find your lordship order at page 12. Can you see? Page 12 is your order, my lord.
Is 12.
Yeah, lordship will come to know, my lord, the background of the case also. This is the case of the who has allotted the work of handling, transport, food, so and so. Handling and transport. That comments from so and so 2 years by FCI that cannot be made responsible for any delay caused by the personnel of FCI. Therefore, the question of liability being settled with the petitioner cannot arise. Senior counsel has also drawn the attention of the court to earlier judgment passed in similar cases where this court intervened. Support of the prayer, they deduct, my lord, right from the day one, they have been deducting, my lord, the demurrage charges. Actually, demurrage charge is fixed by the railways on the FCI, they shift the burden to me. And ultimately, your lordship said, after hearing, it is directed that no further demurrage charges be deducted from the bills of the petitioner till the returnable date. And interim direction would be renewed on the returnable date. Now, my lord, thereafter, what they did, this order was served on the very next day. On the FCI division office at Silchar, also here in Guwahati regional office. Then thereafter they kindly trying to pay
page 7, paragraph 6 and 7, my lord, I have stated.
Of the IE,
Yeah, the I.
is 7.
Lordship. After your lordship said that don't cut the demerits, that after passing the interim direction by this court, FCI has resorted to a peculiar and hitherto not followed unprecedented action, whereby bill amounts only with regard to handling component part have been released, and the bills in respect of transportation component has been withheld in a mischievous manner. Applicant petitioner therefore respectfully seeing their faction, it is preeminent fit occasion, they please to directly respond, make full and complete payment in respect of the bills which were in process of scrutiny on the date, that is the date of interim order passed by your lordship, and the bill submitted thereafter and indicated. Now, my lord, lordship may
Just a minute. Yes. No.
Thereafter, lordship may have a look at the order passed on 24 February 2023. My learned standing counsel FCI submits that as per verbal instructions, the handling charges have been cleared and substantial part of transportation bill has also been cleared during the period of subsistence of the interim order. Let this matter be listed. Same period, he shall obtain written instruction. My lord, that position I am afraid is not correct because of this letter here. They have FCI clearly said that we are retaining the demerit charges. This order, my lord, can you have it? Yeah, my lord, may kindly have a look at that. This is of November, 2 months after your lordship, after your lordship's order. Subject reference, withheld of transport bill for the month of August, September, October amounting to rupees 99 lakhs. Second paragraph. Further, in respect of transportation bill with effect from August submitted by your end, it is informed that since the matter is under litigation and has been held up till receipt of final verdict. That was, my lord, not by the intention of your lordship's interim order. So what I now pray, my lord, they have played enough in.
Yes, Mr. Singh, what is this?
We have in fact released the amount. So,
Show it to Mr. Barbara.
on 1st of March 2023,
Show
on the last,
it to Mr. Barbara.
it was released 46 lakhs, 72,990. It was released on 28 to 2023.
No, that is a consideration, I know. Lordship may direct that you release the bills after the date of interim order. Well, before approaching your lordship, they have already deducted, my lord, 80 lakhs. That will be up to the final outcome of this case, my lord. Now, my lord, lordship has said them, reacted them. That
No,
don't
no, what
cut-
about this, this amount?
No, my lord, this is not the correct position. Lordship may make it clear by saying that
I can
direct.
submit your lordship.
Yes, I have seen it. I have seen it. I am in contact with my client till yesterday. Lordship may, lordship may,
complication of
let me finish. I have seen it. May direct that any transportation, any demerit charges retained by you after so and so may be released. That is, my lord, limited. With respect to transportation bill,
No, Mr. Barbara, we are not going to clarify our order. If they are not complying with the order, they'll face the consequence. We are not going to repeat our orders. We'll give them a chance to file affidavit that they have complied with the order, which was the meaning, the actual meaning, and you take instructions. If that has not been done, then they will
no,
take
here,
some other steps.
my lord, even
On the
here,
last
We are not
occasion, your
going to
lordship-
clarify.
On the last occasion, your lordship has asked me to take instructions, and
Yes.
accordingly, I have been contacted, and accordingly on 1st of March, they have
That is,
Send me an
you file an affidavit.
yes,
Since he's disputing, put this on affidavit, let him have a chance. If at least he should be given a fair chance. Your version it is correct or not?
my lord, instruction from my client is that out of 1 crore 11 lakhs, they have paid 46 lakhs.
While
yes.
Sri A.C. Barbara, London Senior Counsel for the petitioner,
This may be recorded.
he submits that the interim direction of this court has not been completely complied with, comma. 3, BK Singh, London Standing Council, FCI submits that the said direction has been fully complied with. Full stop. In this regard, he has placed before this court a communication dated 1/3/2023 issued to him by his clients, from which it reflects that certain amounts have been paid, have been released to the petitioner, full stop. Sri Barbara, the Land Senior Council, however, submits that the amount in question does not cover the entire amount, full stop, para. In that view of the matter, comma, let the FCI file a preliminary affidavit on this issue to put on record by way of the said affidavit the manner in which the interim direction of this court has been fully complied with.
And the amount, my lord, the total,
Yes,
my lord, released by them after passing of earlier order.
the affidavit should
Indicate.
contain the details of the amount released after passing of the interim order.
In
Let
respect
this affidavit be filed within a period of 2 weeks.
in respect of transportation, handling they are paying, that may be.
No,
In respect.
or the register has not been fully complied. Also, more particularly in respect of the transportation bill.
Except if-
As you are comfortable, Mr. Singh?
12th of May, my lord.
12 May, okay, 12 May.
Let me see.
12 May.
Okay, my lord, today we are on 25th. All right, my lord.
12 May.
Oh, 12 will be my lord Friday, that will be on my lord 11th of May. 11th of
11 May.
Apply.
এইখিনি ঘূৰাই দিব। এইখন হেৰি আছে, তেখেতৰ এই দুখন এইখন খবৰ। Yes, Mr. Tiwari, anything? Good. Date pala na. Day after tomorrow? Day after tomorrow. Which is? মানে other side comfortable থাকিব তো এইটো লিখিব আইডি নাম্বাৰছ কোনটো আছিলে question ঠিক আছে
May I please, a lordship?
yes
Lordship, in this case, lordship, relating matter is relating to victim compensation amount, lordship.
or
Victim compensation amount.
victim okay
Yes, lord. Lordship, affidavit has been submitted, lordship. I think the state as well as lordship, some state legal service authority, lordship. Lordship, their report, lordship say, showing that fund is not available, lordship.
yes what is this what is, fund is not there or what
I'm very 14. And 16, the other standing. In 67, I'm not there in that.
but the issue is the same
I'm not sure because this individual case, because with regard to the conversation.
the subject matter is the same different cases different compensation
The compensation, in so far as item number 14 is concerned, I have filed my affidavit on behalf of Asalsa. So they have not appeared before the DLS concerned. They were required to go and appear before the DLS. That was the instruction at the point of time when I had filed the affidavit.
you have put it on affidavit
I have put on it.
why don't you go to the DLS?
Thereafter, lordship.
No,
Thereafter, lordship.
One second, let madam complete, then we'll come back to you.
my earlier instruction, that was in the month of March, Your Lordship.
Thereafter,
Thereafter, if they have gone and appeared. Today I do not have the updated instructions because the secretary, Asalsa is under orders of transfer and the new incumbent, I'm not sure whether has joined or not.
Okay.
In any case, it is not the Asalsa's duty, it is the district level, authorities, state authorities who are to required to complete the inquiry. Once the inquiry is complete, then if a compensation is due to the person, then that may be cleared, Your Lordships. Funds, of course, yes, in my affidavit also, there is a statement made that there is a paucity of funds, Your Lordships. And
But
if you're-
that issue will come after completion of the inquiry,
yes, Your Lordship.
which would
Certainly.
require his participation.
Yes, I do
And-
not know whether he has participated.
And
in-
he
I
states
can-
that after there are,
14.
he states that after this development of filing our affidavit, he had gone there.
Yes, Lordship.
What is your state, what is your instruction?
Lordship, my instruction is that, Lordship, that whatever inquiry that has been completed.
Completed?
Okay.
Yes, Lordship, as because Lordship, there's a petition also called for.
This is which district?
Baksha, Lordship.
Buxar. Oh, okay. You tell.
Then perhaps the government advocate can get the instructions insofar as the DLSA Baksa is concerned as to what was the report which has been furnished. Which
You can also take the instruction.
I could perhaps, Your Lordships, I
You are the
can
state-
ask. the-
State legal services.
Yes,
you
of
will take
course, I
instruction.
can.
And moreover,
As per 12 January 2023, that no application was received on the.
No, thereafter he had gone there.
Yes.
That updated instruction.
Yes, yes.
Lordship, moreover, Lordship.
Hmm.
The police superintendent of police has submitted an affidavit. In their affidavit, Lordship, this is reflected that case has been sheeted, Lordship, and it is going to under trial.
So, your entitlement or not, we are not going into those.
Yes.
That nobody is denying. If
No,
in the inquiry, it is found that you are actually entitled.
Yes.
If the inquiry goes against you, then the question perhaps will arise.
Yes,
Now you are only concerned about payment part,
yes,
isn't it?
Lordship.
And prior to payment, there is a condition precedent, there has to be an inquiry.
Whether what was the inquiry, whether his entitlement
Yes,
is
yes,
agreed to or not.
the outcome of the inquiry will determine your fate.
Your Lordship.
And let the instructions be received. What is the outcome of the
Yes,
inquiry? Okay.
Lordship.
Third,
I have.
Sri I Hawk Learned Council for the petition. This will be in item number.
14.
14. Your
What
Lordship.
about the other matters?
16 and 17, that inquiry was done, my lord, award is there, but the positive fund that could not be.
Funds will come from where?
Political, Home and Political Department. my lord.
Yes,
And
yes.
that updated instruction was to be placed on our part, but for communication also, we are not. have done it.
Why are you not getting the funds?
Lordships, this is a issue which Asalsa has been trying to raise with the government that the paucity of funds is
No, you are
is
spending.
creating a lot of problems insofar as
You are
payment.
spending lakhs and lakhs of rupees
Yes,
in cultural events. No, you do that, but you cannot ignore these kind of basic necessities.
Yes, ma'am.
Absolutely.
Other three cases, yes, it. And also. As per last orders also,
No, madam will come heavily if you say positive fund.
that is there.
The picture which you are giving to the public, and if this is what is happening, will come heavily upon you.
I'll have the instruction.
You better get advise your clients.
Fine.
Crores of rupees are being spent
Yes, ma'am.
and few thousands of rupees are being held up because of lack of funds.
Since 2021 was.
In item number 14. I have also heard MS M. Burman, the London State Council. Whereas MS R. S. Chaudhary, London Council has appeared for the,
respondent number 3, Your Lordship.
as per number 3, the State Legal Service Authority.
Lordship.
Full stop. Though, as per the earlier instructions, comma, there was some shortcomings on the part of the petitioner with regard to the participation in the inquiry
Lordship.
to facilitate the authorities to come to a conclusion regarding the entitlement, comma. Sri Hawk, the Learned Counsel for the petitioner, has submitted that in the meantime, the petitioner had approached the District Legal Service Authority and an inquiry has also been done.
Not approached, that he was called for.
That is it, you have
No,
to
it
go
was
there.
registered. It was, it's there in my affidavit, Your Lordships.
And the inquiry was, has also been done. Full stop. However, there is no instruction with regard to the outcome of the inquiry. Full stop. Para, under those circumstances, the updated instructions may be obtained by both MS Burman as well as MS Chaudhary within a period of 2 weeks from today. Full stop. Para. List after 2 weeks. Then you write in 15, 16, and 17. Full stop. Your name? Third three SI account, learned counsel for the petitioners. Full stop. These cases pertains to a claim for victim compensation. Full stop. The petitioner, the projected case is that the necessary inquiry is done by the concerned district legal services authority, in spite of which the payment has not been made.
Order also.
Para MS Burman, M. Burman, the London State Council, however, submits that payments have not been released due to lack of funds. Full stop. Para. The aforesaid reason of lack of funds cannot be a ground for delaying or denying payment under the victim compensation scheme, as matters of this kind are to be treated on an urgent basis. Full stop. It is up to the concerned department to look into the matter so that funds are made available immediately. Full stop. Para. However, in the interest of justice, let these matters be adjourned by a period of 2 weeks from today to facilitate the concerned department to arrange and release for the funds. Full stop. If no steps are taken towards the release of funds, this court will explore. The next court would pass adequate orders as deemed fit. Yes.
God bless.
Appeal is a lordship. This matter also same lordship. Here lordship, the victim was a special able child lordship, able girl lordship. He is deemed deaf and mental retardations lordship, and he was ref lordship. The charge sheet was submitted. Everything has been done lordship. Now it is still evidence stage lordship, and lordship, as per my instructions lordship, on 23/2/2023. The petitioner urged as well as his victim girls was appeared before the DLCA, Kamruk Metro Lordship, and whatever procedural lordship has been completed. And in this regard, lordship, an affidavit has been filed, and in affidavit lordship, it is reflected that fund is not available.
This will come under the same next to educative, huh? Yes, same order. 2 weeks. SI account, I hope SI account in WPC, I hope in WPC.
Lordship, this matter may be taken with the
This is a part of this.
I'm appearing in this first one, number. Also.
RS Chaudhary. Okay, sir.
If it will.
Yes, 22.
My lord, in this matter, we were served an additional affidavit by the respondent number 6. We need some time to go through it, my lord. May I pray that the matter may be fixed on 4th.
What is the additional affidavit?
Additional affidavit filed by the respondent number 6, possibly the private respondent, they have brought some new. Some facts documents on record. No?
Mr. Datta was there, I think.
Yes, yes, Mr. Yes, Doctor.
Where is he?
Otherwise, one of Lordship has heard the matter.
Yes.
On the other, the petitioner has submitted. And
Now, what is there? What is there in this additional affidavit? Is there anything new?
some facts, they said that they have tanker for transportation of liquid nitrogen. And of what their financial status. That is their license and all, petroleum license they have in it.
Lord, in this matter, Mr. I. Chaudhary is leading us. Perhaps you would like to respond to this.
Where is Mr. Datta? Name shown or not?
Name is given.
Why nobody is appearing? Affidavit is filed when? Today.
Today, my lord, in the course of the day, we have received it.
Okay. When?
After tomorrow, possible.
Day after tomorrow?
Okay.
Mr. Barua?
My lord, yes.
This court has been apprised that the private respondent number 6 has filed an affidavit today. Full stop. There is a request on behalf of the petitioner for some accommodation so that instructions may be taken on the affidavit. Full stop. Sarah? On the other hand, Dean Leonard, senior advocate Assam, has expressed urgency in the matter. Para. Please also heard MS M. Kakuti, Leonard, Training Council Veterinary. Anyone has been in veterinary department. Para. In the interest of justice, please after tomorrow DTD.
Today, interim order may complete.
Para interim order passed earlier to continue till the next date of listing.
I'm obliged.
Please, your lordship. This matter has been listed pursuant to your lordship.
Item number?
23, lordship. Our lordship has passed an order 27. 23. I had come against the.
Yes, anything?
My lord,
Mr.
the
Gupta?
order was passed, my lord, subject, and the item was subject to continuance of it was, my lord, subject to instructions which
Yes.
may have been, my lord. I have received the instructions, my lord, in a similar matter, my lord, where, my lord, two petitioners were there. My lord, here the interim order is dated 22/2000 at page 23. My lord, in the interim order, there were two petitioners, Deepak and Company and my lord Rajendra Kumar Mangla.
No,
Only Deepak and company.
Yeah, there are two writ petitioners. The present writ petition, my lord Rajendra Kumar Mangla is the petitioner.
Right.
And the another writ petition, Deepak and company had filed, challenging the same impugn order. My lord, that has been dismissed by the another coordinate bench of this court, my lord.
The challenge was the same.
Yes, same order. Same order was in the challenge, my lord, and the honorable court, my lord, came to the conclusion that the catering policy of 2017 does not
My lord.
provide for renewal. And also, my lord, in the interest of the railway, because, my lord, new tender has to be issued and the railway would be getting more revenue and also better quality of service. So, my lord, on that ground, the court has refused to interfere.
My lord, that was subsequent to your lordship's order. And against that, aggrieved by that order, we had filed the writ appeal, and that's under consideration before the division bench of this honorable court. Day after tomorrow, the matter is listed.
You are the petitioner in that case also.
Yes, madam.
Okay, day after tomorrow, then I will have this on
My
Friday.
lord, my lord.
Let us have some parity. Otherwise, if there is an order against you, then we'll have to follow the same order. Unless division bench decides something
Because
else.
Another, earlier, there was a judgment passed by this honorable court wherein relief was granted in similar.
Judgment?
Yes, my lord, by Honorable Justice K.M. Bujarbura and Robin Fukan.
Division bench.
Yes, my lord.
That was.
So because of that, the coordinate bench in another writ appeal had followed that. In fact, our
Okay, you
chief
try-
justice
try- you
was in
try.
that.
Try your luck day after tomorrow. Heard Ms. B. Chaudhary, learned counsel for the petitioner. Also, also heard Sri H. Gupta, learned CGC, appearing for the railways. Full stop. Sri Gupta, the learned railway council, has submitted that a similar challenge was made by two other petitioners in WPC 1828/2023, which however was not, which however was dismissed by this court vide an order dated 31/3/2023. Full stop. He therefore submits that that following the same order passed by a coordinate bench, the present petition is also required to be dismissed. Full stop. Para. On the other hand, M.S. Chaudhary, the learned counsel for the petitioner, has submitted that against the aforesaid order dated 31/3/2023, a writ appeal has been preferred.
Hearing number 124 of 20.
WA,
Yes. lord.
being WA 124 of 2023, which is slated to be listed on
27.
27/4/2023. Full stop. Para. In view of the above and in the interest of justice, place this case on 3rd of May.
Interim order passed earlier. sir.
Interim order passed earlier to continue till the next day of listing.
Much of.
We keep this here, Mr.
My lord.
Matter pending, Mr. Saraf.
Well, in fact, the matter was earlier heard also for 2 days, because of the ECA was expiring, so matter was released again.
The month of whom?
For the Competition Commission.
Yes.
No, item, lordship may take up item 34.
34 is WPC.
6343.
6343. Yes.
Fine. About the Competition Act 2002,
Very live. এখন live.
copy.
We have. Yes, what is the issue involved?
No, this is the matter where the complaint was filed. By 2 complaints were filed. And on that basis, the investigation was directed by the commission. Now the petitioner filed a petition for review of recall the order on 2-3 grounds,
Which order?
Okay.
Initiating the proceedings.
proceedings,
That you sought review of that order,
or recalling of that order on the
Okay.
ground,
but they have not arrived at any finding.
no.
On the
Prima
complaint, no,
facie- prima facie, they have arrived at the finding.
but no conclusion
No,
as such.
Final conclusion has not made.
Okay, okay.
And in that case, we have taken 2-3 grounds. That one, that the first complainant filed some papers and documents, and whereby we don't find that certain documents are not genuine. The person has filed affidavit that we have never given these bills. One of the bills,
Who are the complainants?
one is the Assam Real Estate Development Association, and one is Mr. Rajesh Prasad, Commissioner of Industries, Assam.
Government. One is the community, the government.
So, the 2-3 issues were there on which the investigation was ordered. One was that the issue was raised that they are getting subsidy, various subsidies in the state of Assam for establishment of the.
They means you.
My lord,
Okay,
the subsidies are getting. And that subsidy, in spite of that subsidy,
yes,
the prices are higher.
okay.
Secondly, my lord,
Misuse of subsidy, that is the complaint.
it's not misuse subsidy, my lord. They say in that view of the subsidy should have been passed over to the customers.
That is misuse.
So it's not misuse. I will sort to lordship misuse subsidies.
No, that is the allegation.
Allegation.
On the realm of allegation, you are not saying anything.
Hello.
Oh.
Secondly, my
And
lord,
in spite of the subsidy, the prices are still high, so it's not been properly been, okay, next.
second, my lord, they are saying that, my lord, the prices, spite of all the subsidies here and all those things, my lord, prices at which the cement is sold in West Bengal is lower than the prices at which the cement is sold in Assam.
Assam, okay.
This is the second aspect to the matter which they are saying. Third, the 3 of the companies raised their prices on the same day at the same prices, and thereby there was a cartel. These are the main 3 issues.
Who are the 3 companies?
So this is one, the Star Cement, that is before your lordship. Another Dalmia Cement. Third is, I think, Meghalaya Cement,
Okay.
Adunik Cement. Is, but only Star Cement.
There are 2 petitions before us.
One is against the penalty order of 5 lakhs rupees, first petition. Another is for the 26-1 order.
Penalty is imposed by whom? The commission,
Commission,
based upon the complaint.
not when they were complained, but the delay in furnishing the informations. And I will show to your lordship from the papers and documents that we were furnishing all the informations, and at last date, certain more informations were sought for, which were not there earlier.
That means the penalty is an offshoot.
Hello?
Penalty is an offshoot, not the outcome of the
No.
inquiry. Inquiry is still at the nascent stage.
Yes, yes.
At the very initiation, you have come, okay.
I know, they know doubt about it. In fact, just like the passing of the FIR, my lord, the lordship will entertain it prima facie on the basis of the reasons which have been assigned in the order investigation. If the case is not made out or the findings are perverse, then your lordship will interfere. That is, on that the decisions are there that your lordship will examine it. But it has a far-reaching consequence of the directing the investigation. So if the investigation has been directed on certain materials, like my lord, I submitting that certain invoices which were given, there the
Mr. Dr. Saraf, here the owners perhaps will be about, it's not at par. I think it will be much higher because you cannot preempt somebody from going into an inquiry unless you make out a prima facie case for abuse of powers, lack of jurisdiction. On merits, perhaps we will not enter
no, I will not come to take your lordship.
unless you show something that no, you cannot even.
If I can show to your lordship, my lord, that the subsidy point which have been taken is contrary to the decision of the apex court, the object for which the subsidy is given, it not for passing over to the customers.
That point also will be very, we will examine on a very superficial basis. Would not like to enter into the realm of the adjudicating authority. It's their domain, they'll go into it.
Lord, if your lordship,
Unless you can show there is something grossly illegal or they cannot proceed
Lord,
or there is something gross misuse of the process.
Lord, your lordship will find, my lord, that in all the cases, 26(1) investigation is directed, that I can show to your lordship that such a person, reasonable person, could not have arrived at conclusion, such a conclusion on the basis of the allegations made. Because if the commission is taking a acting investigation on basis that the subsidy has not been passed over,
Yes.
which is not the object of the grant of the subsidy. The object of the subsidy is for establishment of the industrial unit in the northeastern region for better industrialization. And that subsidy amount is not to be given passed over to customers. That is not the object. And that has been held by the division bench of this honorable court also. Where this cinema theaters were there, where the amount was charged from the customers, and the government directed that this will be exempted, and the amount was not passed over to the customers. This honorable court held that no, it has not to be passed over to the customers. So, my lord, if on that basis that the commission has taken the directive for investigation. Secondly, my lord, on the basis that the prices are higher in the without taking into consideration the fact that the discounts which were given by the company is not selling at the prices, higher prices. Like the 400 rupees is the price. I'm selling at 330 rupees to the customer, to the dealers. Now they are selling at 375 rupees at the, or they can sell at 350 rupees. They can sell at 375. So that will not say that I am selling the higher price in the West Bengal and the lower price in Assam, in spite of the subsidy being given. So the factors which were taken into consideration by the commission for directing the investigation, because you're also aware that 26(1), there is no hearing. There is no opportunity given. And the commission takes the view unitarily at its own on the basis of the materials which are available.
You're correct.
If on the basis of those materials, my lord, if I can demonstrate to lordship, my lord, that these are not the materials on the basis of investigation can be directed, because it has been held by the apex court also, my lord, that investigation direction, the investigation has a far-reaching consequences. It's not a normal thing that, my lord, this, otherwise, my lord, in the FIR also, somebody can say, my lord, FIR is there, what is there? You can go for investigation, all those things. So, my lord, this matter was dealt with by the Supreme Court also, by the Delhi High Court in detail. Supreme Court said that he administrative in character. At that time, hearing is not necessary. Prima facie, regions must have some nexus. It cannot be, my lord, the simple the basis of that one. So my efforts before your lordship only to show that these 3 or 4 grounds which have been taken by made by the complainant and which have been considered by the commission are not the ground germane for issuance of the notice under section 26(1) for investigation. If the grounds which have been taken, my lord, lordship, if your lordship find that these are not the grounds at all, then I cannot be directed, my lord, that they let the investigation go on whether the grounds are germane or not. If the subsidy ground cannot be a ground at all, then if somebody files a complaint that the subsidy has been given and they are even selling it at a higher price, that cannot be ground for the issuance of the order under section 26(1) for the investigation. So, my lord, my whole efforts in this one is there. And on that, my lord, the entire grounds which are there, which a lawsuit find, I will go to lawsuit from my written submission which were filed in the recalling order, where I have narrated everything, my lord. There will also find that each and every ground, that how the grounds are not having nexus or the grounds are not correct. Now the commission says that so far as the documents are concerned, which I have submitted, my lord, that's one of the bills which was annexed. The person who issued the bill, he said that I've never issued it. Thereafter, one bill, my lord, he written the lines extra, which are not there in the original. But that amounts to fraud. Now, if the complainant has committed fraud by filing the application for the commission, then on that basis, my lord, the proceeding cannot be initiated. And if it has been initiated, that needs to be recalled. Now, the commission says that these are not only grounds, but there were other grounds
But
also.
do they have does the act give the power for recalling?
No.
No power, my lord, no power.
I will show to you.
That is one point you'll have to cover. There is another, the first aspect of course which you'll have to hear from you is the objective of this act. This is the MRTP, isn't it?
Well,
a new MRTP. MRTP has come in a new form in the year 2002. Objective is the same, monopoly restricted. Now, what is the objective is sought to be achieved by this complaint? Has it got any nexus with the objective of the act? Then, number two, the prima facie satisfaction of the commission to go ahead with the inquiry. For how much power we have to go in roads, we may.
absolutely correct.
Number three, of course, if there is no scope for review, filing of a review, then can we entertain your petition? I think these are the broad points we have to cover.
But this,
Mr. Monta, what do you say?
Yes, my point. Your lordship, kindly see, my lord. Forget about subsidy. I am not on the subsidy part, my lord. Just for the power of DG, my lord. They just took prima facie that satisfied, they got the complaint, prima facie satisfied, they go for, my lord, go for inquiry. So, my lord, DG may, my lord, drop it. He has the power to do it, my lord. If there is a baseless complaint, then he drop it. But can anybody prevent him from going to send?
No, we'll hear that from Mr.
So that is why I am submitting. No, my lord, why?
We have already raised the whether it might amount to preempt.
Exactly, my lord.
That he'll address.
Subsidy, I'm subsidy or not that. Because my lord, your lordship.
No, we made it clear. We are not going.
My lord.
We are not going to enter. We are going to enter into the merits of the complaint. We are not going to enter.
My lord, if your lordship, my lord, if it is board entered in the merit of the complaint, my lord, then my lord, there will be no complaint at all, my lord.
We will not be that authority.
My lord.
We will not step into the shoes of the authority.
And that's
It is their power.
State of Assam file a complaint, my lord. Your lordship kindly see the, my lord, this Star Cement, what they are doing, my lord, the price, yes. Price in, my lord, Bengal, price in Assam, price, entire notice is higher. Entire notice is higher than the Calcutta, higher than the Bihar, my lord. Your lordship kindly even in the Bhutan, my lord. So production is here, but we are giving, my lord, more money. They are my lord, looting entire notice, my lord. And now there is a complaint filed by state of Assam. Last 4 years that is paid, my lord, because of, my lord, there's complaint, there is a stay order and we cannot proceed, my lord.
That's a different matter. Blame it on the court then.
No, my lord, what I am submitting, my lord. There is
Okay,
a
well,
power is there.
yes. Let us hear, Dr. Sir. Yes.
my lord, only because the complaint is by the state government, cannot be put on the higher state, pedestal, my lord, because it empowers the authority, my lord, the section itself says the government can also file a complaint. So only because the state of Assam has filed a complaint, my lord, I don't think that that will have a problem bearing that because this complaint has been filed by the state, so my lord, nothing doing. In all the cases, my lord, the state is the, my lord, when in examining the issues, my lord.
We take 6343.
My lord. I am very conscious of, my lord, my limitations. that what are my limitations and what is the
Both the cases are same petition, isn't it?
same petition. In one case, second case is the only.
Penalty, delay, okay.
Your lordship, when my lord, that is even allow, I am nothing to say. My lord, regarding proceeding that, my lord.
Okay, let us.
No, if the proceedings, my case is not tenable, then I have no objection to proceed. As if you lordship feel that no, there is nothing,
Okay.
then what is there? You proceed.
Okay. Yes.
Well, may I take your lordship to study provisions before taking?
Yes. In your way, wherever you feel comfortable. Yes.
For section 3, your lordship, can you see me?
Anti-competitive.
My lord. No enterprise or association of enterprise or person or association of persons shall enter into an agreement in respect of production, supply, distribution, storage, acquisition, or control of goods or provision of certain services which cause is likely to cause an appreciable adverse effect on the competition within India. So, my lord, the first part you will see that it is to prevent, advance competition in the country. And if any agreement or anything has an effect on the competition, then it will be an anti-competition agreement.
Correct.
Any agreement entered into in contravention of the provisions as contained in section 1 shall be void. So this is also where the competition is not there, or to avoid the, or to restrict competition, then that agreement will be void. Any agreement entered into between entrepreneur or association of enterprises or persons or association of persons, or between any person, enterprise, or practice carried on, or decision taken by any association of enterprises or association of persons, including cartels engaged in identification or similar trade or goods or provisions service, which directly or indirectly determines purchase or sale prices. Now, you'll also make similar that this directly or indirectly determines the purchase or sale price is linked with the provisions of subsection 3. Now, subsection 3, once again, if I read it, any agreement entered into between enterprises or association of enterprises or practice carried on or decisions taken by any association of enterprises or association of persons, including cartels, engaged in identical or similar trade of goods or process of services, so and so. So, the decision must be of the association of persons, the decision must be of the cartel, the decision must be of the enterprises, association of enterprises, and if those decisions of the association of persons has an effect directly or indirectly determines the purchase and sale price, then that will also be, will not fall in subsection 3. Now, secondly, limits or controls production, supply, markets, technical development, investment, or provision service. Now, this also is related to 3. That is an association of persons and enterprises. Thereafter, shares of market or source of production or provision, these are all directly or indirectly results in bid rigging or coalition bidding, shall be presumed to have an advance so and so of the competition. Now, these all 1, 2, 3, 4, A, B, C, D, are related to 3. That is, when a decision is association of person, enterprises, and all those in cartel and all those things, then only 1 A, B, C, D will come into operation. Now we also see, provided nothing contained in this subsection shall apply to any agreement entered into by way of joint venture if such agreement increases efficiency of production, supply, distribution, storage, acquisition, control of goods, so and so. For the purpose of this subsection, bid rigging means we are not concerned with any agreement amongst enterprises or persons of different stages. This also is the other agreement. Now, again, you will also see explanation that what is the explanation of the bid agreement. Then you'll also, for nothing contained in this section shall restrict the right of any person to restrain an infringement of the imposed reasonable conditions as may be necessary, so and so. So, my lord, T, if you're also looking to it, T is only when certain association of person or enterprises act in such a manner that it affects the prices, sale price, the purchase price, and that has an effect on the competition, then, my lord, section 3 will come into operation. Now, if a person is selling higher in West Bengal, higher in Assam, and lower in West Bengal, assuming, for the argument's sake, if I accept the arguments of the complainant, how it affects the competition, how it falls in subsection in section 3. If a person is selling higher in Assam, lower in West Bengal, and another person is selling lower in Assam, then there will be better competition, because a person who is charging higher will not be able to sell them in the market, and a person who is charging lesser can sell it more in the market below. So the purpose of subsection 3 is when an association of persons, 2 or 3 persons join together, bring a cartel to prevent competition. So, the allegations which are there, that you are selling at a higher price in Assam in spite of getting the subsidy, whereas you are selling the same product in West Bengal at a...
For a moment, let us forget that is part of the complaint.
I know.
What about 3 companies
I
raising their price,
Well, I showed
forming
that.
a cartel?
I didn't reply to that one also. Then 40 rupees was increased on the same day. That I have also given reply. Well, my purpose before loss is that if the trade discount, the prices which they are saying that cannot be ground, the subsidy that cannot be ground, then what ground remains is the only that you have increased the prices at one day for 2. Other grounds which are there, which have been given, that I will demonstrate for us, that those grounds will not come under section 3 of the Competition Act. And if those grounds have been taken into consideration by the commission,
Those may be extraneous.
well, that will be, in my submission, will be extraneous consideration. So, my lord, when as you lost is aware, my lord, that when 4 or 5 issues are there in a FIR or complaint, and assuming that 4 has no connection at all, and nobody knows that on what basis, on the basis of what consideration, below that prevailed in the mind of the commission while issuing the notice. Because the commission has said, when the forgery question was raised, they said this is not the only question, there are other issues are also there. So if the other issues, I am trying to demonstrate for us, the 3, 4 or 5 issues were there, out of that 4 have no relevance with the direction of our investigation that is 36(1). Then whether the commission on the basis of those allegations can direct for investigation of the entire things, because you are directing for investigation not on the ground of only why you increase 40 rupees. You are directing for the investigation of the subsidy, and you are asking for documents for last 10 years. This 40 rupees increase and or decrease prices, my lord, that is the event of one time. When you are asking for the emails of last 8 years, lakhs of copies of the documents, what you are going to examine? You are going to examine these 3 factors, which has no nexus, or which are not, on which the commission is not empowered to direct for investigation. At best, the commission, assuming with my limitations and all those things below that the commission asked that why these 3 persons increase the prices on the same day. That may be the sole factor. Now, for that factor, so that's why I was submitting for lawsuit, my lord, that how it is when the investigation is carried out. My lord, if the prices are increased today by 40 rupees by 3 companies, somebody is not going to ask for my documents for 8 years. Because that is the action taken on a particular day. On the basis of which it has been said that a cartel has been created on that particular day. But if on the factors which are extraneous to or which are much beyond the powers of the commission, an investigation is directed and the investigating authority asks for the documents and papers, I will show to your lordship that what are the documents and papers which have been asked for. And if that papers and documents cannot be called for, then in my humble submission, your lordship will not allow the commission to proceed in respect of the matters on which the commission has no power or which doesn't fall within section 3 of the Act. If certain factors are outside section 3 of the Act, that in respect of those factors, an investigation cannot be directed. Like in the FIR, somebody files for a commission of an offense under the particular provision of the Act. You will also the prima facie the FIR only. You will also not examine the correctness and all. If prima facie reading of that shows that no, there is no offense of that one at all. If prima facie on the basis of the statements in the FIR, the offense, whether it is there or not there, ultimately it will be trial. But if no offense is made out, the lordship will not allow the investigation by the police authority to be carried out. The first, the lordship will examine that out of the various considerations on the basis of which an investigation has been carried out or directed to be carried out, if 4, if I can demonstrate to your lordship that 4 are not within the purview of section 3 of the Act, then in my humble submission, the investigation can be carried out only in respect to 1, which in case, if I fail to demonstrate before lordship that that is also not a ground at all, then also that has to be limited to that one also, only, not beyond that. He said, how much time it will take? I said, I was just started one section only.
Divisionless, I'll take 14 minutes.
No, even if you the junior notes it, I'm not going to, it is not going to be over today.
But this is going to take some time, I think.
There are a number of judgments are there and all those, not going to be within 1 hour or so.
You try to do as much as possible today, till 4:15.
Yes, before I lost the relevant provisions and the. Now let's see, section 19.
Others may leave, will not be able to take up any matters.
Item, my lord. Service is complete, my lord. The matter may be listed.
Which item?
Item number 42.
42 cases. That's your paper for whom? No, not his matter. No, is a 6 matter you are not availing. From 42 to. Just a minute, Mr. Dr.
Sorry,
Have a seat. Just
I'm sorry, sir.
Please.
What case is this, my lord? I have got pharmacy diploma.
But
The
registration is not
MA sake learned counsel for the petitioner by referring to the office note dated 24/2023 has submitted that service has been held to be complete for para. In view of the above, in view of the aforesaid order of the learned Lazima court, that this matter be listed for admission as service is complete.
But,
After 2 weeks.
Yes, break right date, my lord.
2 weeks.
Yes. Apply, sir.
What was the matter?
Our land has been taken away by the Jew. Without following the. No, this was, no notice was.
Your Mary Patalan. Jorhat, Mr. Monto? Any, yes, you're Mr. Monto? You, who's for Jorhat? Have you taken steps? Served or not? What is the stage? Service ke liye uthi thi. When was it issued?
Was issued
Let's
on
check the records.
item 20. It's 13. 73,000.
17/3, today is 20. Some office notice. No, not the office notice. Kunya puthi How do? Kunya notice is 28. No. After 2 weeks. Hmm? As service report is awaited. No, don't track like this. Office note dated 24, be sorry, 24/2023 reflects their notices upon respond numbers 3, 4, and 7 were issued. Police. Office note dated 28, reflects that no office notices were issued upon the respondents 3, 4, and 7 by registered post to AD on 28/3/2023. Order office note dated 24/2023 reflects that neither AD card nor unserved notice has been received back. Full stop para. Since a month is yet to be over from the date of issuance of the notice by registered posted AD, list after 10 days with fresh service report. Date seal give, only date seal give. You want a date?
Lord, sir.
Yes, Mr. Doctor, sir.
20 to 30. The contempt and retribution also.
Which matter?
28, 29.
No, no, what was the matter?
Matter basically on the last action, some court said that the contempt will be heard first.
This court had had the matter earlier. Oh.
It was heard by.
Today there may not be.
Yes.
Item number 28.
We'll have it for orders, it'll give a date.
And the item 29 and 30 are wrongly listed.
29/30.
29.
It is pointed out by Sri Saikya and Senior Counsel that though these matters have been listed for hearing, the same are yet to be admitted. What's the para? List for admission after 2 weeks. And 20? 20, which one? The contempt one?
Contempt for orders.
Item number?
20.
28, after 28. List this matter for orders after a week.
After.
Yes.
But they.
Huh? Should it be on the same date? Not necessarily. Let it be on the same date.
And only one thing, in this contempt petition, bank guarantee was invoked by them by violating this own court's interim order. So on the last time, my learned friend gave an assurance that the amount has been in cash, but it will remain intact. That verbal assurance may remain till.
So that order also that will be with us on tenancy.
No.
Anytime this.
They say that on.
You are the petitioner.
Well, I'm the petitioner.
You're for whom?
I put the NH. It is ask me anytime.
So that verbal assurance remains. I must point out. Like.
Yes.
Now we are see I know section 4. Abuse of dominant position. Hello. No enterprise or group shall abuse its dominant position. Number 2, there shall be an abuse of dominant position under subsection 1 if an enterprise or group directly or indirectly imposes unfair or discriminatory condition in purchase or sale of goods or services. Prices in purchase of sale, including PVT price of goods or services. Explanation: for the purpose of this clause, the unfair or discriminatory condition in purchase or sale of goods or services referred to in subsection 1 and unfair or discriminatory price in purchase or sale of goods, including so and so, or service referred to in subsection 1 shall not include any discriminatory conditions or prices which may be adopted to meet the competition. So discriminatory prices, my lord, which may be adopted to meet the competition will not fall in subsection 1 and 2 of section 4. That will not be an abuse of the dominant position. Now, or limits or restricts the production of goods, provisions of services or market is not applicable. Technical or scientific development, this is also not applicable. Indulges in practice or practices resulting in denial of market access in any manner, this is also not applicable. Makes conclusion of contract subject to acceptance by other parties or supplementary obligations which by nature so and so not applicable. Uses the dominant position in one relevant market to enter into protect other relevant market. So you find that the grounds which I placed before lordship, none of them falls in subsection 4, section 4. Now, for the purpose of this section, the expression dominant position means a position of strength enjoyed by enterprise in the relevant market in India, which enables it to operate independently of competitive forces prevailing in the relevant market. So, Milord, dominant position can only be there when an industry or enterprise is in such a position that it can operate independently of competition forces prevailing in the market. Assuming that he can operate independently, such a market must be there. Such a person, the scale of the industry must be there. That a person, a party, enterprise is in such a position that even if the other things are not there, that itself can control the entire market in India. So these are the section 3 and 4. Now we'll also see section 19.
Inquiry.
my lord. This will be important, my lord. The commission may inquire into any elect contravention of the provisions contained in subsection 1 of section 3, or subsection 1 of section 4. So these are the two contraventions for which the commission may make inquiry on its own motion or on receipt of any information in such manner accompanied by such fee as may be determined by registration from any person, consumer or association of trade or association, or reference made by central government or a state government. Now, my lord, if we read A and B, then it has also must be in connection with 1. Contravention of subsection 1 of section 3 and subsection 1 of section 4. Either the commission itself feels that there is a contravention of 1 of 3 and 4, it can itself direct an inquiry, or on receipt of a complaint that there is a contravention of 1 and 2, 1 of 3 and 4, or from the state government or central government that there is a contravention of 1 of section 3 and 4, the commission may direct for an inquiry. So first, it must be established that on the basis of the complaint which has been made, there is a contravention of subsection 1 and of 3 and 4.
3 or 4.
3 or 4. I'm sorry. Now we're losing analysis below. Without prejudice to the provisions contained in subsection 1, the powers and functions of the commission shall include the powers and functions defined in subsection 3 and 7. 3 to 7. 3. The commission shall, while determining whether an agreement has an appreciable effect on the competition under section 3, have due regard to all of the following factors. Now, 3 is at the stage of direction for inquiry. Because section 19 is inquiring. So what the commission has to take into consideration on the following factors, that is in respect of agreements. The loss will find. Now we're losing skipper 4. The commission shall, while inquiring whether an enterprise enjoys a dominant position or not under section 4, have due regard to following or any of the following factors, namely the market share of the enterprise, size and resources of the enterprise, size and importance of the competitors, economic power of the enterprise, including commercial advantages over competitors, vertical integration of the enterprise or sale or services network of such enterprise, dependence of the consumers on the enterprise, monopoly or dominant position, whether required as a result of any statute or by so-and-so, entry barriers, including barriers such as regulatory barriers, financial risk, so-and-so, countervailing buying power, market structure and size of the market, social obligations, relative advantages. Now, these are the factors which is says, my lord, that all or any of them. But the commission must, on the basis of facts, come to the conclusion that a particular enterprise is having a dominant position in the market so as to attract section 1 of section 4 of the Act. Now, for determining whether a market constitutes a relevant market for the purpose of the Act, the commission shall have the regard to the relevant geographical market and relevant market product. You may also see the relevant market when it's to be examined, then this has to be examined by the commission. Now, the commission shall, while determining the relevant geographical market, have due regard to any or of the following factors. These are the factors which have to be considered by the commission while examining the geographical market. These are all linked with subsection 1 of section 4. Now, the commission shall, while determining the relevant product market have regard to any of the following factors. Now, this is the factors. So section 19 has not given while making complaint or while allowed an inquiry. The commission has not been empowered that no, they can just prima facie direct for inquiry. No. Certain factors have been given in the statute itself, which must be taken into consideration while coming to a prima facie conclusion that there is a violation of subsection 1 of section 3 or 4 of the Act. If after considering these factors, the commission comes to the conclusion that yes, subsection 3, one of section 3, which relates to the agreement within the enterprises, which is not applicable in the case, or
Dominant position.
then very can be done. Our lordship will see, I'll show to lordship, whether from the orders even passed, the violation of subsection 1 of section 3, prima facie, only prima facie, I'm saying, I'm not, I cannot request your lordship to go into the merits of the,
Correct.
some of my limitations. Or 4 has been made out. If below subsection 1 of section 3 and subsection 1 of section 4 of the Act, prima facie had not been contaminated.
Just a clarification. The powers under section 19 is a discretionary power for causing an inquiry. It can be done so moto, it can be done on a complaint. But what is required is that there has to be a violation of either 3.1 or 4.1. Now, that is subsection 1 only. Subsection 1 says that under these conditions you can do. And if you come to subsection 2, it makes out exception.
Subsection 1,
No,
subsection
19.2.
My lord.
That is without prejudice
My lord.
to the provisions contained in subsection 1.
My lord.
The powers and functions of the commission shall include the powers and functions specified in subsection 3 and 7, 3 to 7.
My lord.
That is whatever is there in 19.1, that apart without prejudice to it, the powers in the 3 to 7 is a separate powers.
You will see correct. You will see the language of subsection 3. The commission shall, while determining.
We'll come to 3, 4, all others. But first, 2 makes it very clear.
It says 3 and 4.
It is not essentially
one only.
One only.
My lord, absolutely correct. It's not necessary that one only, because you'll also find 1 speaks of only 3 or 4.
Yes, exactly. That is the
1, 3, and 4. And the 3, 4, 5, that are all related to subsection 1 of section 4.
Now, first is 3 is related to section 3, 4 is related to section 4. You're correct.
In fact, the words which have been included, the powers and functions, powers, there is no power in section 3, 4, 5. In fact, 3, 4, 5 all are functions. If you also looks into section 3, 4, section 3, 4, 5, it only says, my lord, that in what manner a particular thing is to be determined. You also may kindly take the table once again. Look. The commission shall, while determining whether the agreement has an appropriate adversarial effect on the competition, and have due regard to so and so. In what way? And what factors the commission should take into consideration?
What we are trying to
My lord.
Extract from you
My lord.
is that 19.1 is a separate power.
My lord.
Then 2 makes it clear that apart from 19.1, there are other powers also. You said that 3 and 4, 3 refers to Section 3.1, incidentally numbers are the same, and subsection 4 refers to section 4.1. But there are other subsections also, 5,
All I'm saying about all 7 minutes.
5, 6, and 7.
All.
Those are not dependent on
You lost me see.
3 and 4.
You lost me see. 5,
5, yes.
5. For determining whether a market constitutes a relevant market for the purpose of the act, the commission shall have due regard to the relevant paragraph so and so. There is no power. Now, lost me see.
Yes, next.
7. The commission shall, while determining whether relevant provision market, have the regard to the following. So there is no power.
These are factors to be taken
Which are to be
consideration
taken
of.
into consideration. In fact, the word which has been, I think, you might use.
Doesn't matter.
The word has been used powers.
Hmm.
But it is should be functions. So I don't find, Lord, from section 3 to 7, any powers have been given.
No, you may be correct. No powers have been vested on the commission by this subsection. It is only certain factors which have
These
been,
are functions in what way, my lord?
yes,
the commission-
factors have been mentioned which are to be taken into consideration.
Consideration for arriving at a conclusion of subsection 1.
Yes.
Now, you'll also mechanically see, my lord. Section 26(1).
Procedure.
Procedure. On receipt of a reference from the central government or a state government or a statutory authority, or on its own knowledge and information received under section 9. Section 9 received, my lord, is says from any information or from the central government or state government or its own motion. If the commission is of the opinion that there exists a prima facie case, it shall direct the Director General to cause an investigation to be made in the following manner. A prima facie case is related to section 19. If, after taking into consideration the various factors which are enumerated in section 19 of the Act, and the commission comes to a prima facie conclusion that there is a violation of section 1 and of section 3 and 4 of the Act, the commission can direct an investigation to be carried out by the Director General. So 26(1) is only, my lord, for directing the investigation. And here is the prima facie satisfied. Prima facie satisfaction is related to section 19. So, my lord, the commission shall have to come to a prima facie conclusion that subsection 1 of section 3 has been violated, which you'll also find is relates to the association of persons or enterprises, or subsection 1 of section 4 of the Act, which is about misuse of the dominant position. And that has to be arrived at. The second part, my lord, that is a violation of section 1 of section 4 of the Act, on various factors which have been enumerated in subsection 3 to 7 of the Act. If after undertaking such a said exercise, the commission comes to conclusion that yes, a prima facie case has been made out for investigation, then section 26(1) can be ordered. Investigation can be ordered.
The use of the expression,
Byron.
if the commission is of the opinion that there exists a prima facie case,
Byron.
is this expression applicable for all the three factors, background requirement? First, there can be a reference from the central government or state government or a statutory authority.
Yes.
Or it can be a suo moto.
My lord.
On number 3, it can be information received under 19.
My lord.
Is the arrival of existence of a prima facie case mandatory for all the 3 factors?
Yes, my lord, your lordship may say, because the 19 is only in respect to all. Lordship may say 19.
Or is it only for an information which is received from a complaint
Your
by any
lordship
other
may- Your
person?
lordship may kindly say.
Just I'm trying to
I'm just
extract from,
asking,
extract
asking my
from.
question myself. No? If somebody said, the state government, if it gives a complaint,
No, what Mr. Mahante was harping
that
upon
is
that,
state government.
that it's a complaint by the state government, so the question of being otherwise being prima facie satisfied may not arise.
I must,
Maybe perhaps that will be his argument.
my lord, this act has a particular purpose. This act has also stated in section 3 and 4 that what will be the violation. Section 19 of the act clearly says in respect
Inquiry.
of all
All.
state government, central government, and below any inquiry to be made under the act. Inquiry to be made under the act. The information may be received from state government, central government, suo moto,
Or any
Or-
complaint.
19. Now, can it be said, my lord, the commission, without being
I think
satisfied,
your, the answer will be in subsection 2 of 26.
my lord,
See, subsection
lord,
26. Where,
my lord,
please read, where on receipt?
whether received a reference from central government or a state government or a statutory authority or information received in section 19, close
The
the
commission,
matter.
the commission is of the
Prima
opinion.
facie, there exists no,
No, the
the
commission is
commission
of
is of the
the,
opinion, there exists no prima facie case. It shall close the matter forthwith and pass the order so in respect of all.
that means prima facie satisfaction is the condition precedent. Sine qua non.
And it-
Unless you are prima facie satisfied, you cannot direct an inquiry by the DG.
investigation. Whether it is from
Whether the
central
complainant is from the state government or central government,
or
doesn't
suo
matter.
moto or from an information. And that conditions have been laid down in section 19. Read with section 3(1) and 4(1). So, my lord, unless and until, in crux of the matter, that 3(1) and 4(1) are violated or contravened, the question of any investigation under the act does not arise. 3(1) and 4(1) are the heart of the act, the object of the purpose of the act. And rest are all to carry out the object of section 3 and 4 of the act. Now, lordship may see section 36(2).
36.
36. Two, my lord. The commission shall have for the purpose of discharging its function of the act.
Yes, yes,
So and so,
yes.
while receipt of so and so, summoning, requiring, discuss, receiving evidence, so and so, the commission may so and so. And thereafter, lordship may see kindly section 41.
Yes, 36(2) is almost like the other acts.
My lord, this is just like summoning and
Act or Arbitration Act, all the powers.
by all powers.
30, then 40,
41.
41. No.
The Director General, when SO directed by the commission, assists the commission in investigation into the contamination of the provisions of the act or rules or regulations made thereunder. The Director General shall have all the powers as are conferred upon the commission under section 2 of section 36. So the Director General will have all the powers which the commission may exercise under section 2 of section 36 of the act.
Yes,
Now, I may take your lordship to directly to the complaint
yes.
at page 43.
Fourth three.
Right. This is by the Assam Real Estate Developers Association. And also may kindly see page 65. Para 2,
Page
page 45, my lord,
45.
45.
Yes,
The respondents above named are 3 dominant cement manufacturers. Also kindly noted, my lord, dominant cement manufacturers in the northeast region of India. Their operations are heavily financed by the government. And again noted, the operations are heavily financed by the government with the taxes paid by the common citizens in the form of huge subsidies under the northeastern policies. Then you'll also see page 46. They have mentioned about the various subsidies which are entitled under the industrial policy. The combined effect of the subsidies as listed above is estimated to be giving its manufacturers a reimbursement of approximately rupees 150 per bag of cement. We have filed an RTI application with the Industries Department on the exact impact of this subsidy per bag of cement and beg leave of honor to allow us to submit the same as soon as the RTI reply is received. So he's saying, you know, that what is the amount of the subsidy which a person is getting, industry is getting, and what will come to the per bag of the cement mill. The respondents have been a leading rampant syndicate of catering by controlling and manipulating the market price of cement market making in the highest in India, in spite of the drawing huge subsidies as aforesaid, and violating clause 3 and 4 of the Competition Act 2002. Now, you'll also kindly see section 3 and 4, you'll also be seen. Now, their allegation is that because of getting these subsidies, I will also also note, these are not only 3 industries which are getting subsidy in the location. There are other 7 manufacturers also in the industry which are getting this. So it cannot be said that because of getting of the subsidies, these 3 industry units have entered into cartel to manage the price. Based on the artificial price hike affected by tactic agreements between the respondents, the entire market price gets artificially inflated, as even the smaller manufacturers who may or may not be in the cartel soon follow the price hikes. We enclose here with case memos, documents market price of cement of the 3 respondents companies as of August 2016, which clearly demonstrate that the prices of all the 3 companies are exactly the same. They're 360 per bag of 50 kgs. This also document a rupees 40 hike in the price during the month of August 16, and that too by exactly the same amount by all the 3 responding companies. The other smaller companies are now following suit with other similarly unfair increases in the market price without any justifiable reason other than the catering. This has loaded an additional burden of 20% to the housing cost, affecting the interest of the large segment of the people in the region. The petitioner being a consumer is therefore highly aggrieved by. The allegation is that, my lord, that the 3 companies, the prices are the same. And in August 2018, the 40 rupees was increased by the 3 companies. and other smaller companies, my lordship, you can note it, my lord. The other smaller companies means,
Raise that price.
my lord, this means, my lord, that the apart from these three, all other cement companies are the smaller cement companies. Lord, to say that the smaller companies, when you say, as your lordship has seen in subsection 3 or 4 of 19, dominant position, the size, various factors are there, which has to be examined whether this is smaller, these are the biggest, how they are the nominal position, that will have to be examined. Now, we were to bring to the notice of commission that the respondents are also transporting their products to distant regions and selling the same goods manufactured in the Northeast at a much lower price in neighboring states. We have collected data from our deadline chapters in Siliguri region, Kolkata, Ranchi, Patna, amongst a host of other regions, and submit here with some of the figures. So and so prices in the Siliguri, Ranchi, Patna, Guwahati. But the prices in the Ranchi are lower, the prices in Guwahati are higher. Now, whether this is one of the factor which falls in subsection 1 of section 3 or subsection 1 of section 4, that the prices in Calcutta are lower and prices in the Guwahati are higher. You'll also see in the explanation. We said discriminative prices is not the factor for subsection 1 of section 4. First of all, which I submitted for lordship, if I give a discount of 50 rupees in Guwahati also and Calcutta also, Calcutta person or Bihar person is passing over 40% to the consumer. But here, if the retailer or so and so is not passing over, then can it be said that the prices, because the company is not selling in the retail? So whether this can be a factor which will
bring in the Act of 2002.
Subsection 1 of section 4 of the Act. Now we'll also skip over 7. The above table also demonstrates that in spite of liberal subsidy, the price of cement has been artificially hiked by these cartels, and the citizens of this part of the country has been used to paying the highest rates in India. We have recently had a discussion with the Dungam Sam Cement Corporation Limited in Bhutan, the manufacturers of so-and-so cement, and they are willing to supply cement at rupees 215 per landed cost at Guwahati. Now, if somebody is selling at 250 rupees in Guwahati, my lord, then to say that the traditional like SAR cement have a control of the market, and by which the petitioners, the markets, people are forced to purchase it, then only the question of dominant position will come. That I am in such a position that people have no other option but to purchase from me. You yourself are saying that somebody from Bhutan is agreeing to sell at 250 rupees in Guwahati. If that is so, how can you say that the petitioner company is having a dominant position in the market and is affecting the price in such a way? Because he is selling at 250 rupees. If I'm increasing the price by 30 rupees, my products will not be sold, or it will be less sold. But if you are getting it for 250 rupees, what is the grievance? He is saying that the consumers have to pay more prices for the cement. Why? You are going to the market, somebody charging 400 rupees, somebody charging 250 rupees. I will not purchase from him. But can you force that person that he is selling at 250 rupees, you must also sell at 250 rupees? No. In fact, that goes against the very concept of the competition. If all the prices are the same, then there will be no competition at all.
Okay, we'll continue some other day.
My lord, only difficulty that Thursday and Friday I'm not there.
Next week.
This week,
No, next week.
next week, any date, my lord.
Rajabana?
Fourth is the Sunday, Saturday, Thursday, my lord.
Possibility of time. Tell us the date.
4th May is the Thursday, my lord.
What May?
In fact, this is the first matter completion act, which is the interim order that may continue to.
Very modern.
I'm a blessed.